7:06 p.m. This open meeting of the Grafton Zoning Board of Appeals is being conducted both remotely and in person, consistent with the temporary provisions of the open meeting law, which extends remote meeting protocols through March 31st, 2027. This meeting is convening via Zoom video conference and in person, as posted on the meeting agenda, which can be found on the Town of Grafton website. Please see the meeting agenda for details on how to participate remotely. Please note that this meeting is being recorded. All participation in this meeting will be visible to others. Anything that's broadcast or screen shared will be captured by the recording and may be published or rebroadcast later. This meeting may feature public comment for anyone that's attending virtually. If you'd like to request acknowledgement to speak, please use the raise hand feature in Zoom, and the meeting administrator will enable you to speak when it's your turn. For those on the phone, the meeting administrator will enable you to speak. Anyone in person will ask you to step up to the podium, and all speakers, please state your name and address prior to your comments or questions. And each vote taken in this meeting will be done by a roll call vote. Okay. So, I guess we'll start with, just do them in order. Case number 92031 Old Westboro Road.
Mr. Chairman, I'd like to
Mr. Adams.
recuse myself from this case.
Okay. Thank you, Mr. Adams. So I will appoint Mr. Langevin as a voting member for purposes of this case. So the applicant can step forward.
We need the legally. We need that pay legally.
Yeah. All right, so first I'll just read the rules of order, and this will apply to both cases this evening. So the petitioner will have, first we'll have the clerk read the petition, and then the petitioner will have the opportunity to present their case. The petitioner will have 15 minutes to present. Petitioner shall present the required information, and all comments should be specific. Anyone wishing to speak in favor of or in opposition to the petition will then have an opportunity to do so. If you wish to speak, please state your name and address for the record. The board may ask questions from time to time. However, all conversation should be directed through the chair. After all evidence is presented, the board will enter into discussion and render a decision. At any time during this hearing and prior to a decision being made by this board, the petitioner has the option to request that the petition be withdrawn without prejudice or continued to a later date, at which time the petitioner could provide additional information favorable to the petitioner. So I'll ask the clerk, Ms. Reed, do you have the petition?
Yes, I do. And this is 31 Old Westboro Road, just to confirm, correct?
Correct.
Okay. The Grafton Board of Appeals has received a petition from David W. Mason, 31 Old Westboro Road, requesting the Zoning Board of Appeals grant a variance from the requirement that vehicular access to the building lot be provided through the frontage of the lot to allow principal vehicular access to the property at 31 Old Westboro Road. To come from North Streets. This is, the board will conduct a public hearing on January 8th, 2026 at 7 p.m. in Conference Room A at the Municipal Center, 30 Providence Road, Grafton, to consider this request and or to take whatever action is necessary, including the granting of a finding, special permit, variance, or other necessary relief allowed under the zoning bylaw. Any person wishing to be heard in conjunction with this request should appear at the time and place designated or by letter to this board in time to be read at the hearing. Zoning Board of Appeals, Brian Waller, Will McKesker, Kay Reed, Alex Mejia, Peter Adams, Jiffy Thomas, and Brian Benjamin.
Thank you. So I have a motion to open the public hearing? Do we have to do that?
No, I don't think we do.
Oh.
We do it to close it.
So I'll turn it over to the petitioner.
Thank you, Mr. Chairman. My name is Henry Lane. My address is 100 Main Street in Whitensville, Massachusetts. And I'm here this evening on behalf of Mr. Mason, who is seated next to me. I guess this property has some history, but we're here requesting a variance from the definition of frontage in the.
You can sit, like, but it's up to you.
Unfortunately, in my business, we're required to stand, so that's what I'm used to
understand.
doing.
Sorry to interrupt.
But usually when Mr. Riley is there, I'm on the opposite side. In any case, yeah, this property it's actually on Old Westboro Road and also on North Street, but there is some history with this property. Mr. Mason and his family have owned it for about 20 years. But I suspect you're familiar with the plan that was submitted with the application. It's a fairly large parcel. The two lots together are about 25, 26 acres, 27 acres, somewhere around there. But it's very oddly shaped, and it unfortunately is encumbered by substantial wetland areas. And just for the sake of terminology, I guess under the statute, you talk about soil conditions, so we call them wetlands, but technically I guess they're hydric soils. So we have a large section of hydric soils which generates wetland type vegetation and makes it difficult to develop this parcel in a normal way. And for the first 10 years or so that it was owned, it was a perfectly legal buildable lot, and for some reason that was lost to history, it wasn't developed. But in 2013, the town amended its bylaw to require that access to a buildable lot had to occur through the frontage, the legal frontage. As it turns out, this parcel has legal frontage on Old Westboro Road of the required distance, 200 feet, I believe. It also has 70 feet of frontage on North Street, but unfortunately the North Street frontage does technically not meet the distance requirement. So we can legally develop the lot by using the frontage on Old Westboro Road, but as I indicated, that access is extremely difficult because of the presence of the hydric soils and the wetland vegetation. It's in fact pretty hard to see how you could do that. You'd have to have a very, very long bridge or a gigantic culvert or something to cross that wetland area to get to the buildable part of what's identified as Lot 2R. But we have good dry access from North Street, so the request this evening is for a variance from the definition and the newly imposed requirement that access has to be through the legal frontage. That's basically what we're asking. We're proposing, as you see from the plan, that we have some upland area, a considerable area of upland on the North Street side. And we have a 50-foot access strip there, 70 feet at the road, but it's about 50 feet as you go further back, which is more than adequate to provide driveway access. And as I'm sure you're familiar, many surrounding towns allow what we call pork chop lots, and this would be very standard. Grafton, I guess, I won't say it's behind the times, but hasn't adopted a pork chop bylaw, so we have to go through the variance process to get it. But I think we technically meet all the statutory requirements, definitely developing it with the frontage on Old Westboro Road would be a significant hardship, simply because it's virtually impossible to cross those wetlands with, as I say, a bridge or a culvert or anything else that could be built. Secondly, the hardship is related to the soil, the hydric soils, so we have the soil conditions issue. And I think we can do it without any real detriment to the neighbors. Now, I understand that at least one of the neighbors has some serious objection to this proposal, But I would suggest that the impact on the neighbor is relatively minor. It's a 50-foot strip. It's going to have a driveway. Whether it had, the full 200 feet of frontage or not, there would be a driveway. So the impact is going to be no different than any other development or any other neighbor. It's going to be a single driveway on the lot between or adjacent to his lot with no real serious impact. Because of its frontage and width, theoretically, we could put a road in there and generate some real traffic. And, frankly, I don't think it's any mystery that, if we can't do something that makes sense with this land, we have to look at other alternatives, which might include building a road or a two-lot subdivision or, some other development that would have a significantly greater impact on the neighbors than what we're suggesting. This appears to us to be, the option that provides the least impact on the neighbors. And as you can see from the plan, we're suggesting that as a condition for approval, we'd be willing to have the board impose, buffer zone requirements in the hatched area on the plan so that, we can minimize any impact on neighbors. So as I say, I think we hit all three criteria, and I think this makes sense from every perspective. As it's designed, Lot 2R has almost 20 acres of area, so putting one lot on a 20-acre parcel seems entirely reasonable and much less dense than any other development alternatives would allow. Now, on the plan, we did show also Lot 1R, which is approximately 6 acres. That also has legal frontage, and I guess the argument could be made that, well, we created a sort of a hardship of our own by carving that off, but in fact, that lot doesn't add anything. It's also, access to that lot is also entirely encumbered by hydric soils and wetland vegetation. We did carve it off on the thought that perhaps, in combination with some neighboring property, it could be used for some purpose. It seemed like, since it doesn't really add anything to Lot 2R, there's really no reason to include it. But if it's an issue that's an issue for a matter that's an issue for the board, we have no problem with dropping that separate lot and including that, so that it'd be one 26-acre lot. As I say, we don't. It'd be difficult to develop on its own, but we thought it might have value to one of the neighbors, or could be used in conjunction with neighboring land for access. But, that's strictly optional. It's not critical. I know if the argument or the concern is that we're creating a hardship on our own, that's something we're willing to give up. That's basically an afterthought on our part, and it's not critical to our application. So that's sort of the thumbnail sketch of what we're proposing. We're obviously here. We'll answer any questions that you may have. And if Mr. Mason wants to say something, I guess he's speechless.
I think he covered most of the basics.
Mr. Chairman?
Mr. McCusker.
So the unique soil conditions, basically being wetlands, as you know, the statute requires that it's not just soil conditions, but unique within the zoning district.
Yes.
And, I don't think that we can, say with good conscience that wetlands essentially are unique within the zoning district, right? There's wetlands all over Grafton, so, I'm gonna get hung up on that part of it right there. The other thing is, I can't help but wonder, even if this was perfectly dry, but there was some other reason you couldn't build a house over in the old Westboro Road area, whether you would build a driveway over to where the house is located. It just seems like, well, I don't want to say it's self-created because that ties into something else, but it just feels like it's not. This lot isn't intended to be built upon. Is just the sense I get looking at it. That's my main concern is it's not a unique situation at all within the zoning district. The other thing I'll say is just, we received a lot of material, a lot of history, and I thank you for not diving into all of that because quite frankly, it's not relevant. So thank you for not going to that, and hopefully we don't get bogged down in a lot of the history. I don't have anything else.
If I can respond to that,
Go right ahead.
there's two things, I guess. One of the reasons that Old Westboro Road is a problematic is that you'd have to put a septic system in, which would, again, be very difficult with the wetland conditions. North Street has sewer, so it just makes a lot of sense to come in off of North Street where you have sewer and water available and don't need a septic system. So that's a serious consideration. Secondly, with regard to the wetlands, the statute doesn't say it has to be unique. It says it has to be something that doesn't generally affect the entire district. And I grant you that there are significant wetlands. In fact, there's wetlands right across the street. But if you look at the whole zoning district, there are very large sections of that zoning district that have no significant wetlands. So it's not a condition that generally affects the entire district. It does affect portions of the district, but not the whole district generally. So I think, again, I think you can make that distinction. At least we make that distinction.
I mean, I believe it. The language is unique to the parcel.
Well,
Are these lots titled to the same individual?
excuse me?
There's two lots here, right?
The plan shows
29
two
and
lots.
31.
Yeah,
And are those titled? Are those both under common ownership?
yes. And Mr. Mason owns both of them. He owns the whole piece. As I say, this was a proposed way to divide them, which we're not married to, If that's an issue for the board, we're willing to forego the creation of the second lot and just merge the two of them into a single lot. If that's an issue, we can make that a condition, or we can just continue the meeting and produce a new plan showing those as a single lot. It's a bonus we'd like, but it's not something that we are gonna make an issue out of.
Any other questions or comments from the board?
Mr. Chair. Just a clarification. So if the applicant would be willing to combine the two into a single lot, you would still be seeking to access the lot from North Street. Is that primarily because of the sewer and water considerations, or is there something else?
Well, the other lot, Lot 1A, is also, 80% wetland. So it really, there's a little bit of upland in the middle there, but it would still be a major effort to try to cross those wetlands. It just, as I say, we see it as potentially usable in conjunction with neighboring land, but independently, we don't think it can be developed, which is why we're willing to give it up. Realistically, if one of the neighbors wants some extra land, we can make a few dollars selling it to them. But independently, we don't think it's developable because you got the access problem, you got the septic problem. The decent access is on North Street where you have water and sewer. And the rest is probably gonna remain in its current state in perpetuity, and I'm sure the board would make that a condition if it votes to grant the variance.
I guess just a small point timing wise. You had mentioned that the portion of the definition of frontage referring to primary vehicular access was added in 2013. I think the original A&R goes back to 2005, so that was added after the fact. But the frontage requirement certainly was in place in 2005.
Right.
And I think that was the cause for the planning board's comment in their original A&R.
Yeah, no, yeah, before 2013, you know, if we presented the plan properly, it would have been buildable without zoning relief. Unfortunately, you know, things happen and, you know, the timing wasn't right and probably didn't realize the zoning change was gonna have that kind of an impact. Kind of, you know, if we knew then what we know now, we would have done something prior to 2013 when it was a conforming lot in all respects, and access wouldn't have been an issue. So it's, you know, from our point of view, it's a relatively minor, a minor request. We're not looking, you know, to eliminate frontage or increase density or do anything of that sort. It's just simply from our view, a technical issue that 2013 bylaw kind of sideswiped us and, you know, created the difficulty that we have. And that's why we have zoning boards. So that we can take care of people who are asleep at the switch and not paying attention.
I don't have anything else, Mr. Chair.
So, I guess I'm struggling with how this is not a self-created issue.
In what respect?
Well, the
Prior to 2013, it was entirely conforming. We could have developed it with just a building permit. So we really haven't done anything that has made it less conforming than it was in 2013. Nothing has really, substantively, nothing has changed. As I say, we did carve out lot 1R, you know, for other purposes, but that doesn't make the property any less, or any more non-conforming, shall I say. And as I say, we're willing to give that up. That's not critical. But from our point of view, this was a conforming lot until 2013. And through nothing that Mr. Mason did, it became non-conforming because of the bylaw change. So it's sort of the classic definition of a pre-existing non-conforming lot.
but isn't the hardship only economic?
Well, economic hardships are real as long as it relates to the land and not to the individual. The hardship is created by the hydric soils. It's not, you know, so financial hardships are considerations. It's not, you know, the distinction always is that it can't be a financial hardship that affects the individual. You know, I'm old and poor. I need to make money. That does not qualify as it's not a qualifying hardship. If the financial hardship relates to the cost of development, I have to blast a mountain of ledge, or I have to build a suspension bridge across a wetland. That's a financial hardship that does qualify, as I understand it.
This has been one parcel for many years prior to me buying it. I didn't subdivide any land off of it, or sell any lots, or sell frontage, or anything. This is how I bought it, and it's been like this for many years prior to me owning it.
Any other questions or comments from the board? Is there any public comment? Step up to the podium.
Hi, my name is Mary Kenedek. I live at 80 North. I'm here to formally oppose this variance. The private well to my home, I can show you here, is extremely close to where they want to put the driveway up alongside my house. It's the land where the driveway is being proposed. It right now is like a private buffer between our house and the neighbor's house. There's daily wildlife, a multitude of wildlife. We have children that play in the yard. I have a pet that plays in the yard. The neighbors behind us have a pet that plays in the yard. I don't see how this, like, I feel like this creates a safety issue, not only with the vehicles, but with the water runoff and the groundwater going so close to my well. I can also show you a picture from my bedroom window as to how close this driveway would be to mine and my children's sleeping rooms, bedrooms. I request that we oppose this variance. I can,
How long have you lived at that?
in May. We purchased in May, we moved in August.
Thank you. Any questions? Thank you. Any other public comment?
Did you want to see the photos?
Oh, take a look.
So. Yeah, so we're at 80, so our well would be extremely close. This is the well.
It's 25 feet.
And this is where they want to build the driveway. Like, this is my well. That,
Mhm.
right, it's 25 feet from these trees.
Yep.
And my bedroom window right here, children's window right there. Very, very, like, it's extremely close.
Thank you. Yeah.
Good evening, members of the board, Mr. Chair. My name is Andrew DeCenzo. I am counsel for Owen Carr, who lives at 84 North Street, which would directly abut the strip of land. Mr. Carr has been traveling out of state, but I understand he is present on the Zoom and observing this evening. Speaking in opposition to the request for a variance, and just a few quick points I'd like to make in addition to the written submission from the other evening. This is not just a typical driveway in a typical neighborhood. As you can see from the plan, the proposed structure is behind the rows of houses on Old Westboro Road and on North Street, and the proposed driveway will go directly through or adjacent to Mr. Carr's front yard, and then the other adjacent abutter's front yard. So this is not a driveway that leads directly to a house. It's a driveway that goes between two houses to another house behind. So with respect to the legal points for a variance, I'll address those. And I understand the board doesn't want a full recitation of the history, but I do think I need to correct a couple of things. Our written submission included the DeSantis decision of the Worcester Superior Court. It was a Judge Lemire decision from, I believe, 2011. If you were to look at page 7 of that decision, bottom paragraph, it says it addresses a prior appeal filed by Mr. Mason with the Zoning Board of Appeals of the denial by DeSantis, the former building inspector, for the zoning permit. The appeal sought to overturn the building inspector's decision on two grounds. One, that the A&R plan does not comply with the frontage requirements, and two, lots must be accessed over legal frontage. So this is an issue that's been out there for over 20 years now. It was addressed by several boards in town, and it was ultimately addressed by the Superior Court in favor of Mr. Carr and the other challengers. And that was not with respect to a variance, but I would submit to the board that the issues are largely the same, and in fact, on a request for variance, they're even stricter and mitigate even more against the granting of relief that Mr. Mason seeks here. And so I'll just focus on two of the points for a variance. One is the requirement for a hardship. And I think that's where we have to go again to the history of this. And on that same page of DeSantis, the first full paragraph, there's a sentence that begins on April 4th, 2005. Counsel for Mason sent a letter to the then predecessor building inspector for the town of Grafton, Ronald DeSantis, and opined that Mason's had demonstrated to the planning board that his access over Old Westboro Road was possible and not illusory. And so now we have a new plan where there's a statement that access to this entire piece of property is impossible, but there's no evidence to back that up. And especially where the exact opposite statement has been submitted to the board in the past, that cannot pass muster for the granting of a variance. With respect to a hardship generally, you need a lot more than it would be uneconomical to build the property given the current conditions. If it's possible to do it, but it may be less expensive or more convenient to Mr. Mason to go from North Street, that's not a hardship. A hardship can be economic, but it has to be that the applicant is unable to make any use of the property for the other reasons permitted within the zoning district. And we heard a suggestion here tonight that if this is denied, then they would look at other uses. We've also heard a suggestion that this lot R1 or 1R could potentially be used for some economic use. And now it may not be the use that Mr. Mason ideally would want to have, but that's not the purpose of a variance. And so the submission that's been sent to the board by the applicant here is deficient with respect to the hardship prong, and that's enough for the denial of a variance. And then I would just briefly address the uniqueness. It does need to be, the statute, it's section 40A or chapter 40A, section 10 talks about soil conditions issue, which are specific to the property in question, don't generally affect the neighborhood or the zoning district that the land lies in. And here, the application itself talks about, well, there are wetlands in the surrounding properties. I think that's enough to defeat the uniqueness prong. But then there's just a general statement of, well, the abutting properties have been able to construct houses, the abutting property owners. We cited a case in our written opposition, the Empire acquisition case that was a 2022 land court decision that addressed and squarely rejected that argument. It left open the possibility that an applicant could make a uniqueness claim on those grounds, but the court was very clear and very emphatic that it's the applicant's burden to show that not just abutting properties, but properties throughout the district itself are not hamstrung by the same condition that affects that one property. And here, especially where we have a proposed division of this property into two lots, it could even be said that those two abutting lots are not unique to one another, and that again could defeat the condition. So really here what we have is a situation where there's no hardship. The issue that's facing this particular property is not unique. It may be more extensive than what faces other properties, but I think there was a comment that, well, this does not really appear to be a property that was intended to be developed, and I think that's what it goes to. I mean, this was a property that was purchased a long time ago, and perhaps there's been some waiting out to develop it for a profit, but that hasn't occurred yet, and that's not the purpose of a variance. And I would go so far as to say that would be outside of the board's authority to grant a variance to accommodate that desire by the applicant. And so unless there are any questions, I'll leave my comment there.
Thank you.
Thank you.
Mr. Chair,
Yes.
I do have somebody who's attending that has their hand raised. Can I let them into the meeting?
We have one more.
Okay. Just let me know when you want me to let them in.
Yep. Right after the.
Okay, thanks. Melissa Durfee, 104 North
You
Street.
can pull that mic down. I think.
Yeah, I know, I'm very short. Melissa Durfee, 104 North Street. I am kind of diagonally across from the proposed property behind my house. And I first wanted to point out from the council, and I completely support your points. I oppose the variance. First off, a road that was potentially, alluded to for a development would not be allowed under the current zoning bylaws because the subject access on North Street is almost directly across from the new development at Clearview. So I can tell you, as far as I know, I'm not an attorney, I work in engineering, but I think it's pretty close. Isn't Clearview Street almost directly across the street? So that would definitely not be allowed. And I did not see on the plans where the proposed structure was. Was that included? And it was there? Okay. So why was only the buffer zone 50 feet from the other homes? To me, that's a little suspicious. Shouldn't it be, 200 feet if we're talking about 20 plus acres? What else? Is this like a bait and switch where you grant the variance and then he comes in with like a 40B? I don't know. So if any variance is even being considered, it must be restricted to a single family home. And I still don't, support that. And then I guess that's about it for my points. There's another property adjacent that's directly across my land, and that's a typical example. They also cannot build on it because of wetlands. So, that's a risk when you buy land that it might not be buildable now or never, at least for the proposed use right now. Thank you.
Thank you. All right. Katrina, you can.
Kim, you can speak now. Just please state your name and address.
Okay, thank you. My name is Kimberly Johnson, and I'm the fiance of Mr. Charles Eric Riggin, known as Eric Riggin, at 86 North. And I just wanted to confirm something. Has the property ever been designated as Chapter 61 Forestry?
Yes, it's in that now.
Okay, so for a 10-year or for the last 20 years? I believe you have to get an extension after the first 10 years?
I believe it's been in for 15 years.
Okay,
Or 12.
so the hardship, where does the hardship come in? Because under the Chapter 61 Forestry, it's a significantly reduced tax rate, property tax rate that Mr. Mason is paying.
I believe you have to pay back due taxes if you pull it out of 61A.
You do, or the town also has first option, I believe, to purchase the property if Mr. Mason decides to sell the property.
Yes.
He couldn't just sell it to a developer immediately, I believe. Is that correct? I'm sorry, I didn't hear you.
Yes, I believe that's the law on forestry land.
Okay. Okay, thank you, sir. That's all I had.
Thank you. Katrina, are there any other?
No, there's nobody else with a raised hand. She was the only one.
Okay.
Got somebody back there had their hand up.
I just raised my hand because that was my fiance.
Oh.
That's why I was raising my hand. Thank you. obviously opposed to it.
So I do have a question. What about this finding in the prior court decision, and I know this is water under the bridge at this point, but that the access over Old Westboro Road was possible and not illusory. And what's the basis for taking the complete opposite position now?
Because we lost the case, we were wrong. Well, I shouldn't say we, because I had nothing to do with that case, but obviously, the result of the case was that, we didn't have actual access from Old Westboro Road. That was the decision. So, we kind of live with that. So acknowledging that that's basically confirms that it's in fact a hardship and we have to find an alternative. So, it may sound counterintuitive, but that's exactly the result. If you conclude that, we made the proposition was made that there was access there. Apparently the town decided there wasn't. Town prevailed, which means we have to find another way in. Fortunately, we have another way. And if they, as I say, it's kind of interesting because apparently the court agreed with the building inspector that even back then, you couldn't that you had to get access through your frontage, which actually wasn't a town bylaw until 2013. So, I can't tell you what else was considered or happened or whether it was appealed or what, but in any event, because of that decision, that's essentially why we're here. Court decided we needed a variance, and now we're here asking for that variance.
Mr. Chairman?
Mr. McCusker.
Yeah, I think there's some confusion, and perhaps it's on my part, but I thought that the prior court case basically was agreeing with the inspector that the lot could not be accessed from North Street.
Right.
On April 4th, 2005, there was apparently a statement made that access from Old Westboro Road was possible and not illusory. So that point is basically saying that Westboro Road will work. I don't think that really that wasn't what was being argued as far as I understand. What was being argued was access from North Street. This statement, about Westboro Road, I think is, I don't want to say it's unrelated because obviously it is, but that wasn't the central part of the case.
No.
And then related to this, I'd actually started to look for this when I first was reviewing this. And I didn't go back to double check, but does anybody have that communication from April 4th? Okay.
I guess the answer is no.
Yeah. I'd love to see it, but regardless, it's it's part of the decision, so it had to. Pretty confident it existed at some point, but okay.
Mr. Chair.
Good job.
So I think various members of the board have expressed some skepticism about the water on the site creating the hardship. But I guess I'd pose this through you to council. Is the access to water and sewer a different animal? The argument could be made that the site could be accessed from Westboro Road, although perhaps incredibly expensive to get through the wetlands. Nothing the applicant can do is going to establish water and sewer access off of Westboro Road. Is that a different animal for any reason?
Are you directing that to?
Yeah, I suppose.
Oh, I thought you were asking.
I take an answer from, I'll take both answers.
I wish the town would
if they
take
don't
legal
agree.
advice from me, but they typically don't want to do that.
I mean, different animal. So, I mean, I think it, you know, if you could, you know, let's say they didn't split these two lots and we can look at this isolated upland area. You know, maybe that wetland crossing would obviously be shorter than to go all the way down to where they're proposing. They're only asking for a variance having to do with the North Street access, but I think there's a practical consequence that if they could somehow build closer to Westboro Road, it's not clear to me where the water would come from or if any even exists. So that is a problem,
Yeah.
I think, but I don't know. I think the short answer is that they're only here for the access question. You know, I don't know if they would argue that that was an additional hardship. I'm not going to make an argument, you know, for them, but I don't know if it's possible to build something, you know, close to Westboro Road. One way or another, maybe it is, maybe it's not.
Anything else to add? Or?
It does not look practical at this point. Otherwise, we wouldn't be here.
Mr. Chairman?
Mr. Gusker.
I don't think that the water and sewer is an issue at all, because their current plan is to go to North Street. And I don't think that would matter whether the house was where they proposed it, or even if the house is all the way over on Westboro Road. I mean, there may be some gravity issues and maybe pumps and things like that, but, so I don't think that's an issue at all.
Yeah, you still theoretically come back to an economic issue. Yeah,
Well,
it might
okay,
be incredibly
yes.
expensive to run a sewer water line, you know, all that way, but
Perhaps,
but we're so yeah, it
as
doesn't feel
expensive
any
as
different.
building a bridge,
Yeah.
I don't know.
Well, and that's what I was just thinking too. The applicant hasn't presented anything on what's the cost of building a bridge or gaining access from Old Westboro Road. I mean, you claim a hardship, but we don't have any context for that.
And building a bridge is very expensive, obviously.
Well, but
And also getting sewer from Old Westboro Road to North Street is thousands of feet through wetlands uphill. And water through wetlands uphill, you know, it's not practical. It would have to be a well and a septic down there, which is extremely difficult. It would be a raised system, you know, probably raised 5 feet because of the water table. I'm not saying it's impossible, but it's definitely a feat to accomplish.
But I think
It's not 100 feet away to get to North Street. It's thousands of, you know. It's probably 100 feet elevation, I would guess, 80 feet, I'm not sure.
But what we have in front of us is, it's less economical for access from Old Westboro Road. But no real context for what is that difference.
I mean, I'm willing to accept that building some sort of a bridge or, you know, a wetland compatible crossing for a single family house would make it uneconomic, considering the distance. I'm willing to accept that. But as previously stated, I get stuck on this idea that you know, that the hardship is tied to wetlands, which I think, you know, is, you know, something that is very common throughout the zoning district. And that's where I get stopped. I also, I'll also, I'm a little hung up on, the intent of the bylaw and all. I mean, people say the intent of the bylaw is, it's a single-family home, and that's the intent of the bylaws. No, I don't interpret it that way. The bylaw is pretty clear that access has gotta be through the frontage. And it seems to me that, we would be definitely going against the intent of the bylaw. But I think that's a little bit more vague in my mind than the lack of uniqueness or the generalness of the wetlands.
Any other comments? Kay, any?
No, no comment for me at this point.
All right, so if there's no further comment, do you want to close it?
Probably should, yeah, I move that we close case 920 to public input. This is 920, right?
Yep.
Do we do that?
Yeah, we gotta do it before they.
Is that seconded?
Second.
Motion was made and seconded. We'll take a roll call vote.
Before you do that,
Oh, yep.
would it be out of order for us to ask for a continuance for a month to address some of these issues?
You could do that.
I think we'd like that opportunity.
I withdraw my motion.
Withdrawn.
So we can, what issues are, if I can, what issues are we,
Well, the two issues that were raised, I think one was the economic aspects of it. I think we can produce some evidence with respect to that. I did look at the wetland issue too. Unfortunately, I couldn't find a set of maps that I could overlay to show what the actual wetland content in the zoning district is compared to, in the zoning district. But I think if we put that together, you will see that it is not generally a condition in the zoning district. And I'd like an opportunity to be able to demonstrate that as well.
I mean, I don't think, I wouldn't, I mean, I think the wetlands issue is, maybe worth it, but, I don't know that you need to necessarily present anything on the economic side of it. I don't know that we can get by the uniqueness of the land anyways.
Mr. Chair, I don't know if, not to put her on the spot, but if Katrina could pull up the GIS with the wetland layer, if that might help. I imagine that's probably what you would be looking at for support, right?
Yeah, but you gotta overlay it on the zoning district. I don't know if that is available.
That's my house.
so on this, is the green all the what?
Green's the wetland, but it doesn't show the district, so you can't.
I think that can be added.
We zone out a little bit.
Oh, in the other direction.
Yeah, I mean, I think if it was more wet, there wouldn't be a neighborhood there.
So the yellow is R40, we're in the R40 zone. So Katrina, if you could move that around, maybe, just show us more R40 area.
Let me zoom out a little bit more.
Yeah, I thought maybe she loses it. It's not looking all that, but doesn't generally affect the zoning district. I mean, I'm seeing a lot of green.
There is a lot of green, but there's a lot of non-green too. And clearly a lot more non-green than green. So I guess depending on how you interpret generally.
I still feel the same way.
A lot of the non-green isn't even accessible by roads, if you look at that map.
Any comments, you have to come up to the board, but
Sorry.
What's that?
Whatever.
No, it's a good drawing.
That's fine. Either way, either try right or what if you vote, I don't think it's or let them vote.
Well, if you withdraw, you can come back within 2 years. The board's leave, we'd like to request leave to withdraw.
withdraw the application.
Yes.
I move that we allow case number 920 to withdraw without prejudice.
Second.
Motion made and seconded. Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Langevin.
Yes.
Chairman votes yes. So case 920 is withdrawn without prejudice.
Thank you.
Thank
Until we meet again.
All right, so the next case is 921. '60 Waterville Street. The petitioner step up.
Interesting on that side.
All right, and Ms. Reed, could you read the petition or the public notice?
The Grafton Board of Appeals has received a petition from Kevin Bowman for 60 Waterville Street requesting that the Zoning Board of Appeals overturn the decision of the zoning enforcement officer dated October 15th, 2025. The board will conduct a public hearing on January 8th, 2026 at 7 p.m. in Conference Room A at the Municipal Center, 30 Providence Road in Grafton, to either consider this request and or take whatever action is necessary, including the granting of a finding, special permit, variance, or other necessary relief allowed under the zoning bylaw. Any person wishing to be heard in conjunction with this request should appear at the time and place designated or by letter to this board in time to be read at the hearing. Zoning Board of Appeals, Brian Waller, William McCusker, Kay Reed, Alex Mejia, Peter Adams, Jiffy Thomas, and Brian Langevin.
Thank you. So I'll turn it over. Petitioner.
Good evening, Mr. Chairman, members of the board, Shane Pickard, 129 Southeast Main Street, Douglas. I'm here on behalf of Mr. Kevin Bowman, who's seated beside me. We are here with an application to overturn the decision of the zoning enforcement official regarding the application of bylaws to 60 Waterville Street. Not my client's property, it's a neighboring property. 60 Waterville Street is located at the corner of, obviously, Waterville Street and a private way called Birch Street. My client lives on Birch Street, and essentially what this comes down to is a question about a parking area that's in the front yard of 60 Waterville Street. There's frequently a significant number of vehicles parked in that parking area, and they impede my client's view as he's attempting to pull out of Birch Street onto Waterville Street. We requested that the zoning enforcement officer enforce section 4.2.3.2 of the Grafton zoning bylaw, which essentially prohibits, on two different bases, the activity and more specifically the maintenance of the parking area there on the property. First, it does not allow the maintenance of a parking area within 10 feet of the sideline of a road. And so the evidence shows that parking area actually is not only within 10 feet of the sideline of the road, but is actually within the layout of the state highway and Birch Street. And then secondly, the zoning bylaw, section 4.2.3.2, does not allow the maintenance of a parking area for over 4 vehicles in the required front yard setback, which in this case is a 30-foot setback in the residential 20 zoning district. Not brought to the zoning enforcement officer's attention, but now set forth in our application is also a violation of the Water Supply Protection Overlay District requirements with respect to recharging surface water, and that has actually led to a discrete issue on the neighboring property that's owned by National Grid. If you're familiar with the area, National Grid installed sorry, I'm not a National Grid guy, but they installed a substation, I think it is, immediately north of 60 Waterman Street, and as part of that installation, they included a drainage system. And I believe on 2 occasions, I'm certain of at least 1 occasion, that drainage system completely filled with gravel and sediment from the 60 Waterville Street parking area. And then the result actually impacted my client because he owns additional land in the rear that was flooded as a result. So I submitted essentially what is a memorandum to the board. I believe that's been provided, sort of countering point by point the bases upon which our application for enforcement was denied. Basically what it comes down to, I think I can summarize it to a slight misinterpretation of the zoning bylaw. In her letter back to us, the zoning enforcement officer mentioned that he had driven by and didn't see a lot of cars parked in the driveway or in the parking area in the front yard. But actually the zoning bylaw does not address cars parked in yards, it addresses parking areas specifically. So it appears the intent may have been when the town meeting passed the bylaw to avoid the need to monitor how many cars come and go, but rather to focus on the conditions on the ground. I've submitted some photographs, some of which were taken by Mr. Bowman, some of which I've taken myself, which show a large area in the front yard, which is largely devoid of vegetation. Again, areas can be seen to have eroded due to rain, and there are some photographs that show in the wetter seasons, such as winter, there is significant rutting in the front yard because of the mud and related traffic there. I think perhaps more importantly, I've submitted a plan that was completed by Gratz Engineering. Interestingly enough, that plan was prepared at the request of the O'Connors, who own 60 Waterville Street. And the engineer also established that there is an area there, which I believe he refers to as a drive and parking area. I believe that plan is before you, or at least has been submitted and should be in the file. So the short version of it is that there is a parking area that the engineer agrees is a parking area. The photographs show as a parking area. And the most recent photographs, which unfortunately the second, that would be the most recent snowstorm, got there before I did. If you look at those photographs closely, you can see that sections of that parking area have been plowed. But if you look more closely, you can see that there are actually snowbanks, which are at the edges of a far more extensive area, which were plowed in the prior snowstorm. And so I think that's really important to look at because it shows. It shows that that parking area again extends not only through and into the 10-foot buffer zone that's established by the bylaw, but actually extends into the state highway layout. I think I'll leave it there for now if there are any questions.
Any comments from the board?
Just one question, 4232. How many parking spaces can you have for a two-family? Because that is a two-family.
Yeah, it doesn't distinguish between.
Is it 4 or 8?
Maximum of 4.
Maximum of 4?
Yeah. Just to be clear, that's within the setback from the road. You can have 100 parking spaces out back or beside the house, as long as you're beyond the 30-foot setback. The restriction only applies to the 30-foot frontage requirement, if that makes sense. And I believe that was a point raised, I hope I'm not out of order. I believe that was a point raised in the commissioner's response to us, that the zoning bylaw doesn't restrict the number of parking spaces. That's true. You can have 100 parking spaces on the lot. They just can't be within the 30 feet from the road.
So if you've got an old house that the driveway's straight in and the house is only 30 feet off the road, they can't park in the driveway?
I would say two things in response to that. Number one, if it's an old house, then this is not
Pre-existing non-conforming, you'd call it, yeah.
right. Which this is not, because this particular parking area, just for a little bit of history, my client owned that house in the past, and so of course there is a 10-year statute of limitations on structures and the statute of limitations on uses that apply to these zoning issues. None of those apply here. The GIS photographs all show that this is relatively recent activity, as far as this expanded parking area is concerned. So if you had an old house with parking that's historically in the front, then it would be grandfathered.
I went by there probably 4 times in the last week, and I tried to do it. I mean, during the day, there's not a lot of cars there. There's the ones in the backyard, the camper, I think there's a boat back there. And I think there's 2 cars with snow on them to the left of the house. And they didn't seem to move in a week, but I've seen the pictures, and we all have seen the pictures that were in the original packet that shows a car right
By the mailbox.
right on the road, basically. I mean, that's, I guess, that's, this whole case hinges on that type of parking. And I see how the whole front yard is plowed. I mean, you can see that in the pictures.
Mr. Chairman.
Katrina, is there any way to bring up the eye in the sky on some Sunday in the summer? I'm serious.
Yeah.
No, we used it on, we had all those pictures for East Street.
So, can I just ask, what's the practical problem this creates? Is it sight lines when you're pulling out?
The neighbor across the street is running a business
Oh.
with the people at 60 Waterville Street. So when their illegal tenant has a friend over, they have to park their vehicles in 60 Waterville Street. When I owned the house, I put an easement in so I could get my trucks in and out of my driveway, which was a parking spot off of Birch Street. When my wife took the house and sold the house to Pat O'Connor, three realtors came down, and I went up and told them, you can't park here because there's an easement there. So they left. My wife sold the house to Pat O'Connor. Pat O'Connor shows up with his van, parks right in the middle of my driveway. He says, hey, what are you doing? Get out. The best thing you do is go get your money back and get out of the house. Don't worry, I won't block you. It wasn't a month later, people are pulling in and parking in the middle of my driveway. I have to take a chain and tow the vehicles out of the way so I can get in and out of my driveway. When I was plowing my driveway, the upstairs tenant come down and told me if I get 1 more inch close to his car, which was parked 3/4 of it in my driveway, it'd be the last breath you take. That was the last day they parked there. Put up the barriers, okay. So then they took and moved all the cars out front, and then all the mud going down, going into the catch basin, which Grid just put $100,000 regen system in, plugged the thing up. There's an intake in my property. The water comes down Waterville Street in the gen, right out into my property, floods my whole field. And then, I mean, they park everything in the whole front yard. You can't see to get out of your driveway.
So I guess that's what I was kind of looking for.
There at the end, if I may, Mr. Chairman, and also Mr. Adams, part of the issue that you're seeing is that they're in Florida currently, is my understanding, that the family, the O'Connors, are in Florida with their horse trailers. So,
Horse trailer. There'd be
RV.
3 trailers back in 3 weeks.
Sure.
Three trailers and 2 trucks.
That's why I'm trying to get
Yeah.
a picture from the sky in
Yeah,
the summer.
I have the timeline of the pictures. Not this summer, but
Well, tell Katrina what the dates are.
well, you can see did this start around like 2017, 2018?
Yep.
Yeah.
About right.
So I have pictures up from September of 2025
All right,
showing,
let's
can you see them right now?
Yeah,
Okay.
if I may.
Yeah, so there's Jersey barriers down here that if you go back to 2018 weren't there and then they were added because they used to park here for years. All of this was green. Parking was here. And then in 2018, April of 2018, Jersey barriers were added here. If you go to 2017, there were no Jersey barriers and they used to park here. So somebody put the Jersey barriers up. Then the homeowners could no longer park in this spot. They had no choice but to go to the front.
Because they were
So
parked on an easement.
I mean, I can go back to 2014. Parking has always been in this spot. Until the Jersey barriers were installed by somebody between 2017 and 2018. Somebody put the Jersey barriers up that blocked them from parking here and here. They had no other choice but to then park out front.
Or come through the front to those spots.
Right. But there was a tree there. I think the tree is gone now if I come up to
That's
current.
gone.
Can you just,
Yeah, that's current.
can you go back to,
This
2018.
one right here is current?
Yeah, this one's current. So 2018, April of 2018.
and then
There's a
if you
there's a
click
tree
the,
here and, huh? I'm sorry.
the arrows where the dates are, can you just
Yep.
scroll through those?
Oh, okay, there's it.
Yep.
Yeah.
So there's April of 2018, 2019.
Can you do by the day or is it just a month?
It's just whenever the satellite went over. So that's the dates we have.
Okay,
Whenever the
now-
satellite pictures were taken.
But if you go back one,
No, wait a minute, this one right here,
and the one
even
before.
on 15, I mean, I don't even think there's a law against parking on the street.
Yeah, there is. Bob
I don't-
Berger-
in the
Bob
win-
Berger told them that they couldn't park on the street.
Oh, I mean, I only know of a few places in town where you can't park on the street where it's posted.
Can you go back one?
But-
Highway maybe one, but
Yeah.
I wouldn't.
Is Birch Street a private or a town?
It's private.
Does the town plow it? No? Okay.
Okay. All right, and then just keep going forward from there. Thank you.
April, June of 21.
What's that is that a truck, those, like truck trailers in the back?
Hay trailers.
Are those theirs?
Those are mine.
Oh, okay.
Well, that's definitely there. What date was that one, Katrina, with the trailer?
This one?
Yeah, 23.
October of 23.
Okay. August Sunday, that's a Sunday in that last 2 years ago, correct?
Mm-hmm. Yep.
Okay. Boy, tell me Big Brother isn't watching us, huh? Jeez, this is awful.
You asked for it.
That's
I
that's
know,
the
I asked
latest
for
picture.
it.
That's the latest picture I have is September 29th of 25.
So, line of sight is in pulling out of
Yeah, if I
Birch
may,
Street.
where I know we're looking at different monitors, but on the, sort of right in the middle there, it looks like there's an RV parked there. And there's a white SUV ahead of it.
Yeah.
Right there. Frequently, they'll back their horse trailer into the driveway right where that white SUV is, and their tow vehicle its nose will actually be within the layout of the state highway, not on the pavement, but within the layout. And that's probably the most egregious. And then, as you saw in a couple of the satellite images, they sometimes park right up against the mailboxes. And again, that's within the layout of the.
Where are the mailboxes? Are they on
Right
the
at the end
corner?
of my driveway.
I mean, you can, I think one of them was a red
Oh, okay.
truck that was basically this, but the aerial view of it was,
That's
yeah.
Mr. Chair,
Ms. Reed,
sorry. Katrina, can you show me where Mr. Bowman's property is so I can I'm seeing it on maybe you guys have some materials that I don't have access to.
He's back here. So he's coming out this street here.
Okay.
If I may, he
All right.
also owns the property to the south on the corner as well. He doesn't live in it, but he does own it, across Birch Street. So the parcel with the trailers, his house is further in the back, in the bottom right corner of the screen. And then he owns
Yeah.
a residence up at the front on Waterville.
58 Waterville Street I own too.
Kevin, do you own, Birch Street?
Yeah.
If I may, with respect to the derelict fee statute, at least half of it, from Waterville down to the that would be the back boundary line of 60 Waterville Street would have passed because it wasn't reserved in the deed, so for whatever that's worth.
I don't understand. Say that again.
Yeah, so if I may point to the diagram here, he'll probably shoot me for this later, but without respect to that, there's a portion of Birch Street right here, half of it, that would have passed pursuant to the derelict fee statute. So he doesn't own that piece of it, but the rest of it,
So who does that belong to?
that little piece of it actually belongs to the owners of 60 Waterville Street. It
But
wasn't
there's,
reserved in the
but
deed.
there's still an easement on it
That's
for no parking, I take it?
You can't, correct, it's
Okay.
an easement for passage, you cannot park in it. Yeah, and then
I-
to complicate things slightly, there is a 5-foot additional easement that he referenced earlier that is actually on 60 Waterville Street. They're the subservient estate, he owns the dominant estate. Again, that is for passing purposes and they can't park there either.
So Birch Street is basically a common driveway for, I take it, you and your brother?
Yes.
Okay.
Well, I bought the house in 70, and in 80, I got divorced. I did research on on Birch Street because Dolphiny said the house that I bought owned that driveway. And Dolphiny hauled out of there for how many years? I mean, a long, long time.
I didn't even know that was a pit at one time. So that was a gravel pit way back? Okay.
Yeah. And then the people that I bought the house from, her daughter gave me paperwork stating that that driveway was owned by the house that I'm living in.
Okay.
But I gave it to a lawyer that lost it.
No,
Mr. Chair?
I don't know why, but I guess I just want to know if it was a town street or privately owned, no
I
reason.
plow it, I sand it, I maintain it since 1970.
Katrina?
I have sightline photos from the street if you would like to see them.
Are those in our packets?
No, they're in a previous case that was a cease and desist with Mr. Bowman, so I do have sightline photos.
I don't know that they're relevant,
Yeah.
Mr. Chairman.
If you want to see what the sightline looks like from the end of that road, just let me know.
Mr. McCusker?
So we are here, over an appeal of the decision of the zoning enforcement officer. And I would love to hear from the zoning enforcement officer about her decision that we're here to overturn.
I was going to get to that. You can, if you'd like to say it, you can.
Sure. Gentlemen? Okay, so I suppose we start with the definition of parking area. Tracy Sharkey, 30 Providence Road. Parking area. Temporary parking more than 4 automobiles. So as we can see on the aerial photos, it looks like a driveway with cars parked kind of scattered around. I haven't seen 4 cars together parked on the property at any time. And I also don't see a formal parking area that can fit 4 cars. I believe the intent of this definition from the time that it was adopted, which I did look up the bylaw adoption meeting and the commentary behind it, was for commercial properties, non-residential properties where they didn't want the congestion of the traffic and they didn't want the cars parking lots to be close to the roads. So I've addressed complaints almost constantly, even when Mr. Berger was here. I've gone out, taken photos immediately, no issues. So I have not seen a violation. This parking or loading area section is not applicable to this property. So that's my position.
The what? Say that again?
Parking loading area section that he's referencing is not applicable to this location.
Why do you say that?
Because there's not more than 4 cars, parking area for more than 4 cars. And the sight line, that's why I was concerned about the sight line. There's a telephone pole. I have the photos uploaded on one of the complaints from 2023. I'm at the edge of pavement, beyond the telephone pole. That's where you stop at. There's clear sight line, both ways, no problems. So that's why I had those photos uploaded in 2023.
Is that what you were going to show, Katrina?
Yes.
Mr. Chair.
Mr. Lynch, go.
The applicant mentioned commercial activity across the street, that people might be parking at 60 Waterville Street and going across the street. Does that, so obviously 60 Waterville is residential, but does the fact that there's commercial activity that could be crossing the street change our interpretation, anything we need to consider?
No, not my interpretation.
And just to go back to parking in the road right of way, isn't that a police enforcement issue?
Correct.
And Waterville Street is a double line road. I don't believe parking in the public right of way is legal. To me, that's a law enforcement issue.
Mr. Chairman?
Go ahead.
So, work with me a little bit here. My driveway, I could put 10 cars in easily.
Mm-hmm.
Right, I just live in a residential neighborhood, half-acre lots.
Mm-hmm.
Is that a parking area? And I think I'm getting into something that Mr. Riley addressed in his letter, and I may go to him next, but
Yes.
is that a parking area?
With more than 4 cars. So if you have a driveway with more than 4 cars and then you move your car to the end.
That's not what I said. So my driveway can fit more than, probably fit 10 cars.
Mm-hmm.
I didn't necessarily say what was parked there. It's just a space, it's paved. It'll easily hold 10 cars or more.
So
Is that a parking area?
Right, but it's not within the front setback.
Part of it is.
4 cars, more than 4 cars
Sure,
area,
yeah, sure.
then I would consider that parking area. If you have
But
four
then- so that would-
cars from the driveway to the roadway, you're telling me you can fit 4 cars?
Yeah.
Yeah. So
In
you
the
would not
front,
be,
in the front setback.
yep, you would not be able to park those there.
You know, people
if you're interpreting the bylaw as it's,
Because that would, I think that would make a lot of the developments throughout town with these illegal parking areas. And I don't think that's the intent, right?
No.
And I think that's really what Mr. Riley got into a little bit in his, you kind of reference a little bit of that.
Yeah, so in general, I think, you know, there's a difference between capital P, capital A parking area and a residential driveway.
Yeah.
I mean, if you're having a Christmas party, you shouldn't get zoning enforcement because the car is parked at the bottom of the driveway. I think this situation's kind of unique just because of the history of the property and the way it all looks. I mean, I think you're right that if there's cars parked in the layout of the public way, that's either, you know, police issue or the select board has control of all the roads, so that's not really a zoning problem. But it seems to me that the parking area really has to do with commercial uses or larger residential uses. You know, the section referencing how far away a parking area has to be from, you know, a lot line, talks about multi-family developments, and that's 3 or more. I believe this property is only 2, so I don't think there's any regulation in town that says a residential driveway is limited in any way in how it can be used. And I think that makes sense. I mean, practically, if it was the other way, then Tracy could be driving around every day writing zoning enforcement letters because people are parking in their driveway, which, you know, is a little absurd.
But there is the idea of a parking area. I think well, let's put it this way. You said it doesn't apply, 4232 doesn't apply because it's not a parking area for more cars. I think is right. So if it was, they paved an area that would hold 4 more cars
within this front setback.
within the front setback, then you would perhaps have a different decision, perhaps.
Perhaps.
Yeah. So I
think
guess
the
that's kind of
distinction-
what's that?
I just think the distinction is a residential driveway from what a parking area is.
Yeah.
The number of
I
cars
agree.
matters.
I agree completely. So how do we get there? I mean, how do you decide what?
Well, I
is-
don't know. I mean, I don't think, in my view, regular driveways aren't regulated.
Right.
On how you can use them. This is also strange because it's different than what you'd think a regular driveway would be. Even to consider it a parking area, it's not striped. It doesn't seem like the parking is consistent or organized in any way where you can actually count how many cars should or should not be there. So it's not ideal, obviously, but it seems like it's kind of a mess. But I don't know where I don't know where there's a technical zoning violation.
My driveway goes down the right side of my property. But there's a whole lot of land to the left of that called my front yard that I could pave.
Yeah.
And park cars there. And I think that becomes a parking area. It seems like it would.
You don't even have to pave it. They didn't. They didn't.
No,
They
you're right.
just
You're right.
plowed their lawn.
I'm just saying, you're right. You wouldn't have to pay it.
If you don't
But if I
mind
just
mud.
started routinely parking 4 cars essentially in my front yard.
But I don't think Grafton has a regulation saying you can't do that. Some towns have that saying you can't.
Wait, I think 4232 says that.
I think it does too.
No, I mean, if you wanted to like park a car in your front yard.
But if I routinely park 4 cars, I got a whole bunch of kids, they're all got cars, and
Some towns say you can't do it for that reason, but
I think 4232 is saying we can't do it.
I think it comes down to whether or not we can opine on if that's a parking area. And I think
Yes.
Sharkey and council have both pointed to a review of the historical record discussing parking areas pertaining to multifamily housing, 3+ units, and commercial development. That's unfortunately not in the bylaw. I don't see it anywhere. But I think, you know, for me, it comes down to how confident we are in that interpretation. If we think parking area as ill-defined is restricted to residential buildings of 3+ units or commercial uses, then I don't think we have a parking area and the section can't apply if it's not a parking area.
I think another thing too, you know, based on their presentation, and I don't think, it doesn't look like the property owners are here to, you know, give their side of it, but, you know, I'm kind of referencing the normal residential driveway. If they are using this as something else, then maybe maybe it becomes a parking area, you know, it jumps to that because what's actually being done there is, you know, some kind of commercial purpose. I don't know, but.
Or something other than a
regular residential use. I mean, I know they said that, and, you know, and I don't know any details one way or another, but I could see where that would, you know, turn this driveway to a two-family house into something different, aside from other potential zoning issues with a commercial use of the property like that.
But I don't understand why we're getting hung up on the commercial piece of it, because 4232 specifically references R40, R20, and, you know, so I don't think it has to be commercial. What Ms. Sharkey said was there was no parking area of 4 spaces or more. And that's when that's what I said. If there clearly was a parking area of 4 spaces or more, would there perhaps possibly be different?
Well, I think the hang-up is because the bylaw defines parking area as an area other than street use for temporary parking of more than 4 automobiles. And Tracy said she looked at the history of, you know, when these things were passed and they were discussing, you know, commercial situations. And I think it's her interpretation, you know, that the temporary parking reference means something different than like what a residential driveway would be. Like I wouldn't consider my driveway of my house to be like my temporary parking area.
Yeah.
It's my driveway where I could leave a car there for 20 years if I wanted to, and no one could do anything about it.
Yeah.
Mr. Chairman, may I just make a couple of comments? Sure. First, I think it's really important. Mr. Langevin,
Sure.
Langevin
Close enough.
pointed it out. There is no distinction in the bylaw with regard to commercial and residential. That's not in there. That's a really important point because I agree that this is a residence. I've personally spoken to one of the guys from across the street, but I'm not making that argument. This is a residential property, but the bylaw does not distinguish. In fact, it literally the heading, which oftentimes is not taken into account, but literally says generally applicable provisions. So this clearly applies to both commercial and residential. And had the town meeting wanted it to be limited to just commercial, they easily could have drafted it that way. And when the AG's office reviewed it, they easily could have given that feedback. So I think that's really important. Second, I think there's an important factual distinction on these words we keep tossing around. People keep saying driveway and parking area, driveway and parking area. I think if we just stop for a moment, we'll quickly understand the difference between a driveway and a parking area. And I think the principal difference that we all know is true is that one of them allows you to access multiple spots without moving all the cars. And the other one, if you have a whole birthday party full of people parking in your driveway, you got to back them all out and come back in. Right? There's a difference between a driveway and a parking area. And if you look at the photographs and if you just look at the size of this area that's at 60 Waterville Street, you'll recognize the fact that you can move easily, and I'm not exaggerating, easily 8 to 10 cars into this parking area and move any one of them back out again without having to move any of the other spots. And that's what makes it a parking area. So I think that's an important distinction. The bylaw does give some definition of parking area. It does not distinguish that from driveway, but the courts are very clear that ordinary dictionary definitions is what you would use in that case to distinguish between a driveway and a parking area. Because I do agree, Mr. McCusker, that if it was driveways, then we would have major problems because all the driveways in the zoning area would be in violation. That's not the case. Driveways are typically narrow, typically built for one car to pass up and down, and that's why we all have to run out in the middle of the birthday party to move the cars. The O'Connors don't have that problem.
When was this house built? 70?
61.
In 61, you probably didn't even need a plan, so no one would have, well, I mean, like we do today, you have to show a house, you have to show the driveway.
Right.
I would love to see that, but they didn't do that back then.
The driveway was a one-car parking spot,
Is that coming in from
Birch.
Waterville?
Birch Street. You come in Birch Street and was right there at the side door.
Yeah, but you just shot yourself in the foot because you said they can't come up Birch Street.
There's an easement there. You can't park on an easement.
Oh, they can cross it though.
They can cross it,
Okay.
but it's 7 feet from the easement to the house.
Oh,
And when they got kicked out of there, they just moved out front. And when I put the easement in, I tried to put a driveway in the front yard.
is there a curb? Is there a curbing on
No.
on Waterville Street? No, so there's no curb cut.
Well, Bob Berger told me it was because of, water going back into the ground. I couldn't put the driveway in. I spent $20,000 trying to put a driveway in the front yard
Off of Waterville?
off of Waterville.
That's what happens when you ask permission.
It looks to me like the whole front yard is a parking area.
Yeah.
It might not have been dug out and gravelled, but
Well, also, if I could just add that there's been nothing submitted to me that there's a parking area within 30 feet from the front setback. So I do not have a plan that shows a parking area. I do not have within the 30 feet front setback.
from the, all right.
Front setback.
Did they give you these,
So-
did they give you these pictures?
Yeah,
Oh,
but where is the front setback?
If I may, that is a scale drawing. All you need is just to check it, and you can see that, I mean, as I said, that the parking area is actually within the layout of the state highway, and it extends through the 10-foot space. It's clear as day on the plan, if you just look at it with the scale.
I guess I'm not seeing a parking area on the plan either.
If I may, it's indicated by a dash line that comes in close to the north corner from the pavement edge. It's a dash line that comes in to the east, and then it kind of does like a funny two-finger thing and then hooks back down to the house. It's that dash line.
which one are we looking at?
Which picture are we looking at here?
Oh, I'm sorry, we're talking about the plan that was submitted. This is the plan by Graz Engineering.
I don't have that.
Oh, wait a minute, I think
oh,
I think Graz's is in our packet.
Isn't it?
I don't know where these other two came from.
I believe those are old A&R plans related to
One is 1963. And, the other one's 1990 or around there.
So the 1990 plan would have been the one by which Mr. Bowman established that.
So this, we're looking at the one by Graz?
Yes, Mr. Evans.
So that's not it. Does anybody have that?
Yeah, right, this one, in your packet.
Oh,
It's also on the screen.
That must be that one, yeah, that one, yep.
Mr. Chairman, if I may just indicate again that this is a plan that was prepared by Gross Engineering at the request of the O'Connors. This is not a plan where my client called up an engineer and said, hey, exaggerate the parking area.
But that's what's on the screen.
Yeah, that's right. And the parking area is actually the Gross engineer.
Is that, is that August 12th, 2000? I can't read that, what year? Too small.
2020 was the date.
2020?
Yeah.
Well, I mean, you have a real plan, I have a,
Would you like to? Ma'am.
no, I'll take your word for it.
Katrina, can you go back
20
and see the
2020?
parking area? Yeah. Tracy, you've not had this before?
I probably saw it at some point, but I don't believe it's defined and there's no measurements and the front setback's not shown on it. And from the aerial photos, it appears like there's a driveway, one goes to one unit, one goes to the other unit, and there is not room for, well, I can't even tell within the 30 feet if there's a parking area for more than 4 cars.
But that 30 feet regulation only applies for a residence containing 3 or more dwelling units, which is, this is not.
Where does it say that?
In 4.2.3.3. It only applies to a parking area serving a multifamily dwelling. And multifamily dwelling is defined as a building designed for and occupied exclusively as a home or residence and containing 3 or more dwelling units. And this is a 2-family house.
So it doesn't apply then?
4.2.3.3 doesn't apply to this property.
So then within 30 feet, you're
The 30 feet
So you
parking
can
area
be- so you
setback
can-
does not apply.
So you can be within 30 feet.
Yeah.
So
Well,
really,
but-
the only thing that comes down to is 4232, which says you can't have a parking area which is more than 4 spaces.
Right, so I think the question is this a parking area or not?
And Tracy, you're saying you can't determine whether it's parking area because it's not really established, right?
Correct, and every time I have addressed the complaint, I immediately leave the office, take photos, which we have, I think, 3 or 4, and go to the site to see how many cars are there. So,
But respectfully, even that, you wouldn't, unless it's surveyed, staked, you still would be going off your best educated guess as to where
Yes.
the road layout ends and the
right,
setback begins.
yes.
But
So,
I saw more on a Saturday than I did on a Tuesday or Wednesday, because I went there yesterday also.
Yesterday, you
How
saw,
about at
how
night?
many cars did you see yesterday?
I mean, there's the two to the left of the house as you're looking at it from Waterville Street that haven't moved.
0
Then-
to,
And then the ones out back, but out front there was maybe 1 or 2, but nothing near the road. But, I mean, these pictures are evidence that he's seen them, and he's seen them in the snow, because it shows them packed there with the snow. And it shows that plowing the whole front yard.
There's 3 trailers and 2 pickup trucks are in Florida. They're at a horse show. They left November. Last year they left November, they came back the middle of February. So after February, gonna be a full yard again.
You might want to continue till April.
it doesn't matter.
Mr. Chairman, if I may,
30 feet
just
doesn't apply, so they
a couple of things that have been said.
So that they can't.
With regard to town council's comment on
No,
4233.
4 is up here, that does apply.
hold on.
Sorry.
The 30 is here, that doesn't apply because it's multi-family.
Do I look at this?
Yeah.
I think Mr. McCusker just was talking about my point. 4233 is obviously a different section than 4232. That section only applies to multifamily dwellings. The section immediately preceding it, from a statutory interpretation perspective, definitely applies because there's no limiting language there. So just to be clear, again, the section we're talking about does apply to residential properties. The other thing I think is really important to be careful about getting hung up on here. I know we want to talk about the cars, because obviously it is an important element here, and it's our primary complaint on it. But the bylaw does not prohibit parking cars anywhere. What it prohibits is the maintenance of parking areas. And I would argue that if you drive by there every Tuesday and every Sunday and every time we call and there's no cars in the driveway, that does not satisfy the will of the town meeting when they said there shouldn't be a parking area in this particular section of the property. The problem is the parking area. Now, I know it's cart before the horse kind of stuff because parking area, they've chosen to establish it by repeatedly parking in it. But the evidence does bear that out. This is not a situation where we're claiming, hey, this is a parking area and there's never been a car in it. The cars are there, it's been plowed, there's muddy ruts in the photos. I do believe, much to my chagrin, that when Miss Tracy goes down there, the cars are not there. When I can't explain that, all I know is sometimes there are cars there, sometimes there are not. But the parking area is there all the time. You can go see it right now if you'd like to take a look. It's always there. And the photographs from the satellite bear that out.
I know some of the older ones, you could definitely see the lawn. Then it's transitioned.
Yeah.
Now the grass got killed or whatever. I don't think they removed the grass or the loom. I think they just parked on it and plowed it and whatever, and it,
Kevin from the highway department is sick and tired of cleaning out that catch basin after every rainstorm.
what is it, mud from their yard going
Yep.
into it?
Yep, I got plenty of pictures of it. Full stream of mud right out of the driveway, right down the road, right into the catch basin. And Grid's entrance into that manhole is only that far above the drain, the regular drainage for the septic system, for the water.
And that is a separate issue because the property is fully within the water supply protection overlay district. So all of that additional, which I never brought to Ms. Sharkey's attention in fairness to her, because I wasn't aware of it frankly at the time.
And I guess just point of information from the new guy. Since that wasn't part of Ms. Sharkey's decision, are we able to consider it?
No,
So I don't
it's
think
not
we can.
for us.
Wait a minute, what?
So the water supply protection overlay district concerns, like they weren't part of Ms. Sharkey's decision, so I don't think we can.
Mr. Chair, is one of the issues because you've, Ms. Sharkey, if you've never, because you haven't seen 4 cars there, is that,
I haven't been supplied any evidence that
Of
there's
for
a
more-
parking area, yes, that would be considered the definition of the bylaw.
And
That's
so
my interpretation.
and then every time you mention a couple times, every time you've gone, there's just been no cars or like 1 car or 2 cars?
The usual, there's like a boat, there's a trailer, there's where the, unit on the right is, there's 2 cars parked there sometimes. We have a 10-foot vegetated buffer around the perimeter, so, they've been maintaining that distance. So they've done that. If we zoom in on this, we can see where the telephone poles are actually on their property that are laying down in the Jersey barriers. So they're going 10 feet from, their property line on that side. So they've been maintaining that buffer. I've had many conversations. And then the aerial photos also show the driveway access as one main access to either side of the duplex that's there.
So I guess my next question is do we not have photos of 4 cars sitting in that area?
I've submitted past photographs, which I believe should be in your packet. I
But-
can tell you that right now, they're not there, they're not home. I think the most I've seen is 3 cars there right now.
But even in these photos, I'm not seeing,
Oh, I'm sorry, those photographs were taken just within a week. Those,
okay, because there's not 4 in these photos.
correct, those were the
Okay.
photographs from the last snowstorm.
Oh, here's one right here. How far is it from the telephone pole?
I have surveyor stakes in my driveway.
No, I mean from like the mailboxes with the
I
telephone
have
pole.
surveyor stakes in my driveway, and Grid's got surveyor stakes on their property. Had surveyor stakes. Land management across the street tore the one out of Grid's property.
But even in these photos, I'm only seeing, I mean, let's just assume, I guess what you're saying is that there is a car there, because it looks like there was a car there, so we could say there's 2 cars there. And then, are you saying that there's 2 cars behind those cars?
No, not at all. Those photographs were taken by me within a week of today, maybe 2 weeks ago.
So,
So I guess what's,
but I don't think the fact that there's 4 cars or 6 cars or 2 cars there matters. Isn't the decision whether or not this is a parking area,
well,
period?
I thought yes.
Yeah, so it's whether it's a parking area. And then
But we don't,
the sub-question to that is, for the parking area is defined as temporary parking. And you kinda have to determine whether this use as temporary parking or more permanent parking?
Well, it would seem illogical that temporary parking would be prohibited and permanent parking would be allowed. So I don't know that we would need to.
Well, no, I think the point is, and I think that, when you look at a parking area, right, so what is temporary parking? Driveway or house is not temporary parking. The parking lot at the bank is, because you can't leave your car there all the time.
Mm-hmm.
So, you know, what does it mean to be temporarily parked or, you know, for more than 4 cars? Is that what's happening here? It would be helpful if the property owner was here to maybe, you know, explain a little more about what they were doing, but we don't have the benefit of that, but yes, whether it's a parking area or not, and whether the cars are temporarily parked.
Temporarily is a good word, and I'm gonna remember that, because,
The bylaw, it's not coming from me, so.
it's like, what's the definition of a
That's in the
repair?
bylaw?
That's the definition of parking area. An area other than a street used for temporary parking of more than 4 automobiles.
That's in your letter, isn't it?
Mm-hmm.
But it doesn't mean that there has to be 4 cars there.
Well, that's what I thought it meant, because that's why. It's not considered unless there's 4. Is that what it means?
But I think
I
just
think
by, sorry, go ahead.
I think you're saying the same thing. It's not literal cars. I think it's the space. That's a space that allows for more than 4 automobiles.
Right. Yeah.
Mr. Chairman?
Mr. McCusker.
So when I look at this picture, right, I see the front yard has been plowed.
Yeah. Did you plow yours?
No,
Why?
because I don't park.
Well, it might be a fad now, I don't know.
But okay, but in all seriousness, I guess when I look at that, what else could that be other than a place to park? You know, what else could that be other than a parking area? And then when you look at the aerials that we showed earlier, that all sure looks like a parking area. So I guess that's what I'm struggling with is.
That's what I'm having, I mean, if it looks like a duck and quacks like a duck, it might be a duck.
Well, but one other consideration, they would need to plow that area if they wanted to access the parking that's to, as we're looking at that picture, to the right of the building.
Not that way.
Not that much. Not that much.
Mr. Chairman, may I make just one comment on that photograph that Mr. McCusker is looking at? That series of photographs, which I took, again, I think it's important to note that while there is an area that's clearly plowed, you can see the ground. If you look closely at those photographs, there is a larger area where the snowbanks from the prior storm got pushed to.
Mm-hmm.
So the parking area that you're talking about is actually larger than it appears in those photographs. And again, I'm not making that up. You can see the evidence of it in the photographs. You can see dirt pushed up and, you know, that kind of stuff.
Tracy, have you talked to the owners at all? Would they just kind of move everything back 25 feet on their own and,
I've never seen them parked within the 30 feet.
okay.
So we have an entrance that we can see on the TV right now. So you have to try to use your imagination for 30 feet in. And that is to their unit. Then the driveway curls around to the other side of the unit,
And that,
the duplex,
and those are the lot lines, right?
approximate.
Yeah, approximate within, whatever, couple of feet at the
Yeah.
most.
Yeah.
I mean, we have a picture of the car right almost near the pole, so it's gotta be on town property. That came with our packet,
And,
that red.
and there were
vehicle.
aerial photos as well,
But more than 4.
but not
Parking area.
simultaneously.
Yeah.
That's what I'm.
That's what, I don't,
Yeah,
So the area itself, how do I prove that four cars, more than 4 cars can fit there? If I don't have any dimensions, I don't have a plan submitted with my request for enforcement. So what am I going by? A few photos that have no measurements on them, that have no dimensions. It's my denial of their request, their specific request, did not support me enforcing the bylaw. So yes, we have, there are cars moving around. This is a long history here. I have talked to them many times saying, do not park within the 10 foot of the side setback, maintain your buffers, do not park, don't park in the sight line. We can see this plan, you can see the edge of the roadway, you can see where the pole is. It's way forward. So where you're meeting they're not parking where that grass, I know there's not a lot of grass there, they're not parking there. So my request from the applicant for enforcement did not support this interpretation of the bylaw or give me any evidence that there was a violation.
Mr. Chair, can I ask a question again?
Please.
So I think that's why I asked if there was 4 more cars there, because if there was 4 more cars, then it would be an issue, or unless they were parked within that, within that grass area. And
More than 4.
More than 4, and you have not seen more than 4.
Never.
Once.
And that would be clear evidence that that was a parking area
So
for me.
And to your point, and I think you both mentioned it, whether you guys said whether there's 4 cars or not, even though it looks like a parking area, that doesn't matter.
But that's my interpretation.
So because it looks like a parking area, I guess we're in your defense, it doesn't really matter unless they're using it as a parking area and there's evidence that there's 4 more cars, or it's within their parking and outside the zone.
But we'll have to make findings. I would support a finding that this area holds more than 4 vehicles.
There's 8 unregistered cars in the lot.
Hold on. Mr. Chairman, may I just make a couple comments? First, really important, I believe, I submitted this engineering plan with my original request for enforcement. I realize it does not have the 30-foot setback, and not every dimension you could want is on there, but it is a scale engineering drawing with the scale on the bottom of the paper. So you can determine the size of the parking area to a reasonable certainty and determine how many cars you could fit in there, again, to a reasonable certainty, just because it's a scale drawing. That's why it's required. Number 2, Mr. Mecchi, I think if you look at the file, which I know you don't have before you, but the photographs I had submitted to Ms. Tracy previously, and then they were also provided to the board, I believe, in your electronic files, perhaps. You'll see the photographs with more than 4 cars. So that's important. I think that evidence is also present.
But I guess in regards to the interpretation, though, if I let's just say that entire lot that we see in the front was paved with pavers and it looked pretty with pavers, but cars weren't parked there, would that be an issue? I guess it wouldn't. It still wouldn't be an issue. I guess what you guys are saying is because it looks paved, but there's only been 1 or 2 cars there parked with what we have as evidence. So sorry, Kevin. It doesn't matter.
Well, for one thing, they can't pave it.
Exactly.
Because of the water protection overlay zone, they can only pave so much.
So, and that's what I mean. We can't, because it looks like one, we can't just assume.
But I think we can use our common
That's
sense
what I
and
mean.
our, just observations that this area has more ample capacity for 4+ vehicles.
And you also can consider there's the actual driveway access. So we're talking back to the party time, right? So we're not counting the 0 to the 30 right in front of the house, because that's the access to the parking area for that second unit. And we're not counting going from the street to where the cars park. They're not doubling up and having, blocking people in on either side. So we're not counting, if you're saying, okay, the area, so the only area would be the north side. but we're not counting that front portion right in the front of the house to the street. Cause the second unit parks on the side there.
So it's a pass-through essentially.
Yes.
Yeah.
So there's,
Mr. Chair, may I ask the applicant a question?
Sure.
All right, so the board can affirm the order or denial, overturn the denial, or modify it essentially, issuing a different type of order, right? So what would like a different type of order look like? Like, what are these people allowed to do on their property?
So the order we requested would contain two things. It would order them to stop parking within the 10 feet from the front line of their property, which is approximately 24 feet, I think, from the edge of the pavement. So they wouldn't be allowed to park in there, and then they would only park, or maintain parking, I should say, for up to 4 cars within the 30-foot setback, which would be between that 10-foot line in the front of their house, or wherever the 30-foot.
And that would apply to their, and I know you've said they've used the property more than just a normal residential use, but that would apply to a residential use if they had a couple people over? It's just, I'm having a hard time understanding that part.
I think it's a question of where they maintain the parking. So, for example, if they came in off the road and then they had 4 parking spots, and they had people over and those people parked behind them, even right up to the edge of the pavement, I mean, that's permissible. Because as it was, I think it was, Mr. McCusker was talking about his long driveway. Parking in a driveway where the space is normally maintained open for the use of the homeowner to get to their parking spot, right? Temporarily parking someone in at the birthday party, for example, is different than parking there regularly and using that spot for routine parking. So if I maintain 4 spots, but then my friend comes over and parks me in, he's not in a parking spot, he's in my driveway, and I gotta tell him to move before I can leave.
Right, but what if someone in Grafton just wanted to park at the bottom of their driveway?
Nothing we could do about it, because it's a driveway, not a parking area.
Right, so the question is whether it's a parking area.
Correct.
Okay.
That's right.
Can I see that big plan?
Mr. Chairman?
Augusta.
So I just heard it brought up, both of the attorneys, this idea of 30 feet. And I thought we established that the 30-foot does not apply.
Oh, I don't think it applies.
No, I think it does in 4232 because, so it continues, no parking or loading area shall be located within 10 feet of the street line, period. All right, that's stands long. No parking area containing.
Oh, in the front yard, okay, yeah.
Yeah, so it
Yeah,
references
okay.
nor within a required front yard in R40 district.
Yep, no, you're right. So the front yard is 30 feet. Yeah.
And
Okay,
if
so the
anybody,
30 feet does still apply, okay. So, all right,
I'm sorry, Mr. Chair. So if anybody's curious what approximately 30 feet looks like, I just emailed Katrina. So GIS lets you do measurements. And I did a measurement from the edge of the road layout towards the house, and it's basically the entire distance from the road layout to the house. The house is, the deck, that side deck facing Waterville Street is basically 30 feet from the house.
30 feet from property line?
30, yeah.
but that portion also allows access to the other side. So the people.
Right. So some portion of that theoretically is driveway to the side of the
Correct.
house.
So the O'Connors, they park like at the, beyond the house portion, as to not block their tenants.
I don't understand one thing on this plan. Maybe you can interpret it. It shows telephone pole, but it looks like a telephone pole laying down.
That is indeed a telephone pole laying down, yes.
Okay, but they didn't put the regular pole that's standing that shows in the picture.
Yeah. This is a pole, a utility pole, right here with the little squigglies. That's a utility pole. This is overhead.
So are you basically saying this utility pole right there is this one?
Yes, sir.
Well, this trailer then is basically on town property. Okay.
Mr. McCusker.
So, as I said earlier, we're here because we're being asked to overturn a decision of the zoning enforcement officer. And the zoning enforcement officer has said she doesn't see a parking area. And I have said, you know, and I held up this picture and said, well, it kind of looks like it. But you know what? I'm not gonna overturn her decision off of, well, it looks like it. You know, she's the professional, and I mean, I know it, we have it's kind of our job to, you know, kind of be the checks and balances on her, but I think I would need something a lot more substantial, which I think is exactly what she's asking for also, that says this is a parking area. I don't have it, so I don't see how I could vote to overturn her decision based on, sure, looks like a parking area. I can't do it.
Can we, I know they can ask for a continuance, but can ZBA ask for a continuance to like May? Cause they did state summer weather, other vehicles come back, and it makes it worse.
But you haven't just looked in the last couple of months.
No, it's been 2 years.
In all the pictures we flipped through, I don't think we saw 4 vehicles in front of the house in any of those pictures.
If I may, I'm sorry to interrupt, but I've said it repeatedly, I know it's a little bit confusing, but I submitted those pictures from just about a week ago. There is a whole other group of photos that you should have in the file, and if not, Katrina will have them, that I submitted to the building commissioner that show far more cars in the driveway, so that's the evidence I'm talking about. I acknowledge that the photos I just submitted don't show that, because they're not there, but the other photographs do show that.
I wonder if it's worth buying a inexpensive drone. I'm serious, and
So,
Do you need a permit to move your driveway from here to here?
if it goes out into the street, yeah, you'd need another curb cut. I would assume.
You said that they could park anywhere they want.
Okay.
That's what Pat
Yep.
O'Connor told me.
That's hearsay, let's not bring it up.
Do we,
Don't do that.
I'm looking for these pictures. Do we have the case file there, Brian?
Yeah.
What, these pictures, Bill?
No.
The ones in the packet or the ones they just gave us?
Supposedly there's been other ones submitted.
Oh,
But it's coming up on the screen now.
I could,
I just put them up on the screen. I'll scroll through all of them for you.
and sorry, before you go, so when you were in that prior photo, the prior slide that you had up, because there was one car there parked right in front, that's not a violation, right? So unless we're seeing, and regardless if it looks like a parking lot or not, I think we need to be clear on that. It's unless there's 4 cars, it is not considered a parking lot.
I disagree with that.
or how about
That's
if,
what it,
how about if they're within the 10 feet? That's a violation?
I don't,
It's the side setback. So we're talking within the 30-foot front setback.
Wait a minute. How many can park within the 30-foot setback? None?
More than 4. Cannot. So
So
4
o-
can.
whoa,
So,
more than 4 cannot.
so,
This is more, the definition is more than 4.
so in other words, the
I need to see 5 or more.
Yes, 5 or more.
5 or more can or can't?
Can't.
Can't.
If it's 5 or more, it's a parking area.
Yes.
And the 10-foot setback.
So where they plowed the whole front yard, because we're not seeing a picture with 4 cars in it, doesn't, that,
We don't.
I mean, I guess there's no law against plowing your whole front yard.
Correct.
I'm sorry, Mr. Chair, can I ask another question? It doesn't state because it looks like a parking lot, it doesn't matter whether it looks like a parking lot or not. Is that,
Well,
Council,
when
am I correct on
when I
that?
think of parking area, I think it's describing like what's on the ground. You can have a parking area with 20 parking spaces and 2 cars in it. It doesn't matter how many, I don't think it matters how many literal cars are there. It
And-
matters how many cars are in.
Okay, so
And that's what I'm saying. We don't need a picture with 4 cars.
Okay,
Or
so
5
that's
cars.
that's where I'm confused because Ms. Sharkey is saying unless there's 5 or more that which she hasn't seen, right?
Yes.
Then it doesn't qualify. But if it looks like a parking lot, then it does.
No, I think she's saying it has to be 5 or more because there isn't, parking space lines laid out. There isn't other stuff to make it very obvious that that's a parking area. Right now, it's just a grass blank area. So how can she call that a parking area, especially when there's not even any cars parked there, right? But if they'd actually drew parking spot, stalls, and that sort of thing, or somehow made it very clear that these are places to park cars, then how can you say it's a parking area?
But, so, just by,
Wait a minute, what's how many cars in that picture? I see 3.
I think one's clearly in,
And
the,
I'm
in the
can
road
you
layout.
zoom in on that one?
The other zoom. There's 4. Is that a 4th one on the right? Yeah,
I think that's a tree.
but even if it is, I mean, it shows the red car,
That truck's 10 feet.
that red thing is definitely in the town right away.
Yes.
The next one is definitely within the 10 feet.
30.
So,
We're struggling to
Yeah.
establish whether this is a parking area or not, which
Mr.
is
But I-
exactly what the zoning enforcement officer, I don't see how we can overturn her decision if we can't even come to terms with it.
Mr.
But
Chair. Oh,
I-
sorry.
one thing though, so I think we can differ in the interpretation of it. Because I completely understand her interpretation. But I don't agree that just based on all of the other evidence here, and knowing that it's not staked out, there's no lines, there's no, consistent surface. I don't know how it's clear that it's used regularly for parking. And I don't know that it needs to be a formal defined area to be considered a parking area. If just based on repeated use, that's what it turns into, which is essentially what happened. They made no effort to turn it into this, but by their use of it, it's now compacted and, used for that purpose.
But she has to make a decision that would stand up under appeal, that would stand up in court. And she doesn't have the evidence to support it. And, we're here to overturn her decision or not. I would think that we should also have the evidence. And that's where I'm stuck with, yeah, it looks like it, but I don't think that's sufficient. Now, you may disagree with that, and that's fine, of course. But,
Well,
we're here over her decision. Well,
but circumstantial evidence is evidence. It doesn't have to be.
I mean, half their case is that they're parking within the 10-foot setback. Isn't it?
Yes.
Two separate.
I mean, that was evident right in that photo. They had one car, the red one was on town property, and the white car was definitely within, I mean, how wide's a car? 6, 8 feet?
I don't think Tracy's decision even mentioned a 10-foot, did it?
Well, that only matters if you determine this to be a parking area.
Well, they're parking there, so,
Well, I know, but if it's a parking area, they can't park within 10 feet. But if you consider it to be there's no definition in the zoning bylaw, but a regular residential driveway, the 10 feet requirement doesn't apply.
So if he parks there every single night,
but that isn't a driveway, that was the lawn.
Separate issue, I suppose, but.
So 2 cars parked every single night in the 10-foot area, two is not a parking area.
No.
What is it?
It's just 2 cars parked in the
Just two
10-foot
parks
area.
where they're parked, yeah.
how many cars are allowed on the property?
Kevin.
So there's also that other word. So you had mentioned, okay, we're using the area consistently. Would you consider that temporary parking?
Yeah,
I
that
don't
word
know.
confuses me.
I'm not really sure either, why that's in there. But you would think, I'm going to CVS, I temporarily park to go inside, I come back out, I move my car. That's why the commentary from the original adoption of this, maybe the wording was not quite right, and this, I think this 4232 morphed also. But that was to address congestion and location of a lot of people parking near the roadway. So that leads me, so an area.
But isn't that
other-
what we have here?
Well, you said it's permanent though, because we consistently use it, same exact person uses it and is there for 8 hours. I'm going to CVS, I'm there for 10 minutes, it's temporary. It's not consistent or permanent.
Mr. Chairman, if I may, what the building commissioner is suggesting is that we don't want cars permanently blocking people's view and the side of the roadway, but it's okay if they leave their cars there permanently within the 30-foot setback. I think that's a difficult interpretation to accept. And by the way, I'm not saying it's unreasonable, I think it's difficult here.
Well, we have that word there.
I
That's why we're
agree.
discussing it.
I agree.
And we're, yeah.
Yeah, it's reasonable, I get it, it's a struggle.
Mr. Chair. I'm not sure if this helps kind of square the circle on parking area or not, but where I get hung up, I think I would be comfortable calling it a parking area whether we saw cars there or not, if it wasn't for the fact that we do have lots of photos of parking to the right of the building, and you need to get there somehow. So I think what I would need to see to evidence the fact that we can fit 5 or more cars there and still provide access to the side of the house where we've seen cars repeatedly over years. That's why I would feel more comfortable with a photo showing 5 more cars there. It's like, all right, well, it happens. Whereas I think one of Ms. Sharkey's points is, we don't really know what would be parking area and what would be kind of pass through to get to the right side of the house. So yeah, the whole thing is paved, but are there 2 parking spots that are paved? Because they're parking spots, they're intended, the homeowner intends to use them as parking spots, and the rest is paved to get access to the right side of the house.
4.2.3.2 also references spaces.
There's nothing paved in that yard.
Or designated in any way.
When he took me to court, the judge ordered him to go to land court and pave his yard.
Well, Mr. Chairman, if I may, just briefly, in response to town council's comment, I believe Katrina had pulled up the photographs that I had submitted previously.
Yeah.
I think only one of them was actually shown, but there is, I know at least one photograph in there that shows, I think 6 or more cars in the area, so.
Katrina, could you do that? And there was one that I happened to see where you could see where cars had been parked.
The ruts.
Yeah.
There's 8 unregistered cars in the yard,
Okay.
which I don't care about, because they're on the back side of the house.
Oh, but I think that would be a separate enforcement issue.
Yeah,
That's
I
come before the
understand
board.
that, but she's talking 4 to 5 cars. There's already 8 unregistered cars in the backyard.
There's no limitation on they can park all these cars.
I
in the backyard.
understand that, but she's saying there's only 4 to 5 cars in the yard.
So you can see 1, 2, 3, 4, 5, 6.
No, but the ones up by the, electric company there, that I think is a driveway.
No,
No, that's not a driveway, that end of the property?
no,
Oh,
that whole front yard was all lawn, all the way around.
I mean, that picture right there makes it a little bit more clear that it's a driveway to get to the other side of the house, which is exactly what Miss Sharkey, I think, was saying. Did I just put words in your mouth?
No.
Yeah,
Very
so
nice.
that looks more like a driveway than a parking area.
but that, where that trailer's parked, that's not a driveway.
Yeah.
That was
Actually,
lawn.
can you go back up one?
That pickup is on Loom.
Oh, sorry. Maybe it was down. Sorry.
I mean, if we gotta see a photo, I really haven't seen one yet with 4 in the front yard or 5 yet.
I guess there's a picture with the backside of a vet, the black vet. I think they're up. Going, bingo. Where is that?
We're
That's the
standing
next
on
door
Birch.
neighbors.
We're standing on Birch.
Standing on Birch.
Oh, that's the telephone pole right there.
Yes, that's correct.
Okay. Did you put that pole there years ago, Kevin? Okay.
Stop them from blocking my driveway.
Oh.
I was training cars, dragging them down my driveway so I go to work.
I'm still in the same place. I'm not seeing enough to overturn her decision.
Mr. Chair, just to let you know, there is an attendee raising their hand to speak, just so you guys know.
I was wrong. Gravel drive and park. The whole front yard.
Oh. Who prepared this?
Grads. They're out of Fitzwilliam, but they have they used to have, I don't know if they still have an office in, Worcester, but they did. But, I mean, that says, I didn't notice that before, but that says gravel drive and parking, whole front yard. Show that to Bill.
Yeah, no, I see it. So,
This one,
But it's drive and parking.
right.
huh?
It's drive and parking.
Yeah.
So what's the driveway, what's parking area?
But just by leaving it vague, it can be used as either.
I guess I'm trying to see if from Tracy's point of view, is that a parking area? And prove to me that that's a parking area, or how can I prove it's a parking area? Maybe it is, maybe it isn't. And even Graz has, maybe it is, maybe it's both. So it's vagueness that I have trouble getting to a point where I can overturn her decision.
Tracy, what like the most important thing that leads you to conclude this is not a parking area?
Any real-time evidence. The photos are undated. I have no idea when those are from. I have photos from 2023. And the use of the property and the lack of any evidence that they qualify. So it's the burden of the applicant. And also, we have to go by when this was requested as well. So I'm acting on the request. I've denied the request for enforcement based on that moment in time. So that's what they're trying to overturn. So just want to bring it back to, there was a request from the applicant at this date in this time, not necessarily 3 years ago, 10 years ago, 20 years ago. So they have not proven to me that there's any violations at the property. Does that answer your question? And I've also not seen what my interpretation of the definition of parking area is. I have not seen that on this property.
I think that's more what I was getting at.
Yeah. With on-site, with documentation, with plans.
But is it because this plan?
That was provided by the applicant. I mean, the owner. That was drawn for the owner of
Right.
60 Waterville. Yeah.
And it says gravel drive and parking.
Yeah.
Why do we have a copy if the owner paid for this? Did the owner give this to you, or where did this come from?
I submitted that. I got that from Gross. It's a kind of a long behind the scenes story, but
Okay, okay.
also, Mr. Chairman.
Well, I mean, the pictures at least show that they're in violation of the 10-foot setback? No?
No.
Parking in it?
I think we would need to conclude, or the enforcement officer would need to conclude it's a parking area first to bring any of the other
Oh,
terms into it.
okay, so you can park there overnight, no big deal, because temporary?
No. We're saying it's not temporary. We're saying 5 or more cars.
Can I?
Sure.
So, I think where I'm confused, and I think, you know, as much as this is, you know, confusing, and it obviously clearly looks like a parking lot, the bylaw does not say it's a violation because it looks like a parking lot. I think that's where I'm confused. The trigger in the bylaw is what she's mentioned if there's more than 4 vehicles. Appearance of worn grass is not itself the violation. So the violation occurs only if there's factual condition in the bylaw is met, which is more than 4 vehicles. Worn grass is not the legal basis. I think that's where I'm getting confused, because we can't just because, you know, I don't know. I want to, you can't judge a book by its cover, I guess is what I'm saying. And part of it, and the other thing that I'm getting confused on is part of that, because now there's those barriers, it's also a pass through to where they actually need to park that's not within the setback, that's outside of the setback. And where they're parking, they're not in tandem, they're side by side, and it looks like, you know, to your point, they can, you know, pull out and go as they please. It's not.
So if there was one, I don't know what date this was specific to.
October, maybe? October, thereabout? The request, the date of the request?
Just October is good enough.
I think so.
So if there was one photo from October showing 4 vehicles, would that be the smoking gun? That
5.
5, more than 4.
I can get you.
I would say, yeah,
I can
they're
get you
utilizing it.
6 car pictures right now. Go home and take the pictures, come right back. 6 cars in that lot right now.
Okay.
And there's 5 of them in Florida.
Please.
So, I don't think, even if it's 5, I mean, it's evidence that would maybe support the finding that it was a parking area, but if it's not a parking area, the fact that there's 5 cars there doesn't make it one. It's whether it's used for temporary parking or you know, a more permanent situation.
Or within.
As
the-
those
or
terms are
within-
undefined in the zoning bylaw.
And that's what I'm hung up on. You don't need. It seems like, or my sense is that we're looking for this smoking gun evidence, but in my mind, there's enough circumstantial evidence to show that this is used regularly for parking.
I agree with you.
Mr. Chairman.
And I mean, this shows on the plan, parking area.
And then we're also looking at within 30 feet. So we're saying the house is at what distance off the front setback?
Brian,
It was just under, or just over 30 feet, to the edge of the deck.
Okay, so when
Based
they're
on the
parking,
GIS.
when they're
measurements.
parking beyond the front
20
face
feet
of the
to an
home,
inch. How
that's
far is
not,
that to there?
that's not a parking area. So that's the other section, the 4232. No parking loading area shall be located within the 30 feet.
So it's not just 5 vehicles, it's 5 vehicles in the front yard,
Yes.
in front of the house.
No?
No,
Oh,
no. If it's not a parking area, none of that matters.
right.
If it is a parking, so if you determine it to be a parking area, then you look at those, you know, how it's set up and where they're parking and how far away from the lot lines.
Right, that's what I'm saying. So it has
Right.
5 vehicles in front of the house. 5 vehicles behind the house, not a problem. 5 vehicles in front of the house, problem.
Only if it's a parking area.
Well, yes, okay.
And then I think we have
That's
to,
like step one, is it a parking area?
Right.
and I think we have to consider, what Ms. Sharkey was able to find going back to when definitions were changed. I don't know if it was the definition or the, 4232. But speaking to parking area being intended to address multifamily housing, 3+ units, and commercial. So if we get there, then we're kind of done.
Mr. Chairman, if I may, I believe Katrina said sometime back that there was a person online with their hand raised. I just wanted to bring that back to your attention.
I probably should hear from them.
Katrina, do you want to allow them?
Hey, can everyone hear me?
Yep, I just need your name and address, sir.
Yep. My name is Nicholas Talcott. I actually live at 57 Waterville Street, so I believe I was referenced a few times this evening, and there's quite a bit of mischaracterization of what's been going on, so I kind of want to help clear that up. First off, there isn't a commercial business being run out of either property. My wife runs an online and mobile tack business with her partner, Liz O'Connor, who lives across the street. So there's no temporary usage, right? We're not having people shop in our house. So that's false. I also want to highlight the snowbank issue. I work from home, so I see Mr. Bowman when he plows, and he's the one who actually plows those snowbanks up on either side of Birch Street. It's not something that the O'Connors do. He's the one who kind of builds that up on either side.
We're not talking about Birch Street.
Correct. But, you mentioned the snowbanks, and he's the one who plows the snow up onto Waterville and Birch Street to block the view himself.
I don't think that's come up at all.
Okay.
It's not really part of the discussion.
Okay. It was like 2 hours ago. I've been here for a little bit. But anyways, the other thing I want to call attention to is that plan. And I think what Mr. Bowman's lawyer is trying to call to the fact that they had this engineering piece done to kind of show this was a driveway, which is 100% false. They actually got that done due to Mr. Bowman putting the Jersey barriers on their property. So that was just a survey done just to show the property lines and to show that Mr. Bowman was actually trespassing on their property to block their access to their property. So this is kind of a bit of self-inflicted wound on his part, putting those up. And they also noted that a judge ordered them to pave their front yard. That's also 100% false. There was a harassment hearing over COVID with Patrick O'Connor and Mr. Bowman, and the judge just said it's a better idea to go to land court than anything else. there was nothing with paving. So there's been a lot of mischaracterizations of the O'Connors and their property usage. I just wanted to clear up.
Okay, thank you. Is there anyone else, Katrina? Katrina?
Katrina, you're on mute.
Sorry, nobody else but him.
Okay, thank you. So, I don't know. I'm kind of at a loss. It seems clear to me that this is a parking area. And I know that's not a universal sentiment.
Myself, I think it's a parking area myself too. But
I also understand the reasoning behind how this came
Right.
to be, the bylaw, and that it wasn't intended to be residential.
I also think it's a parking area, but I don't think, I don't think that we know that, or there's enough evidence to support it being a parking area to overturn the zoning enforcement officer's decision. You know, my gut sense says it's a parking area, but, there's just not enough there. That's where I'm at, and I think we gotta consider that. I mean, do we have the required evidence? Wish us was like some of the other things, like variances and all, where it's very clear what the findings have to be. Fortunately, we're not in that situation, but I don't feel strong enough or I have enough evidence to overturn her decision. And maybe the thing to do is close the hearing and let's make a motion and vote.
or would the applicant want some time to gather more information?
But, hold on though. So, this kind of goes back though to the point in time, right? October of 23.
That's what you're deciding on.
Right.
This is not an open-ended thing. It's the denial of the enforcement request from October. And I'll also bring you back to parking area definition. So I wanna make sure you're saying this looks like a parking area, but does it look like used for temporary parking of more than 4 automobiles within 30 feet from the front line? You're saying it looks like it.
Yeah.
Doesn't justify.
From where? From what document?
Just
the
enough
pictures.
pictures of cars
So
in
for
various
temporary
spots.
parking. So that meets, so what you think, what you're seeing used for temporary parking of more than 4 automobiles within 30 feet
Yeah.
of the front setback, front.
Mr.
Yeah.
Chairman, may I just mention one thing that I think is important?
Mm-hmm.
The idea that this inquiry is related to a specific date in the past is I don't believe accurate. It doesn't even make sense, because if that were the case, then the whole thing would be meaningless. Because every time we went down, by the time she even looked at it, that date would be passed, and then she would just say, oh, that date passed. That's not the question. The question is whether there is a continuing, the existence or maintenance is the word that the bylaw actually is, the maintenance of a parking area. That's the question, whether that's ongoing. And I think we can all agree that if there had been back in October and then that maintenance ceased and they weren't using it, that we wouldn't be here. I have other things I could be doing, and I'm sure you all do as well. It's a question of whether it's being maintained, and I think the best evidence of that is actually the snow plowing, but that's my opinion.
Mr. Chair, I guess the question would be if we were provided, because I still think in the photo, I think the definition is if there's more than 4 cars, just because it looks like one. I mean, I guess it's, we can use the temporary case, but if we were provided a photo, within recent time, a photo of 5 cars parked there, then what happens? I guess at that point, do we say, all right, it's now considered a parking lot?
But
It's now considered a violation.
well, that's what I'm saying. We don't need this smoking gun picture.
I feel like I do. I feel like based on the definition I feel like that's what we need. I agree. I think it looks like a parking lot. But based on the definition, we can't call it a parking lot. So that's where my confusion is. But my question still stays the same. If we get a photo with 5 cars, then from there, is that what turns it over? Is that what would turn it over in your mind?
If it's within the front setback.
Within,
And then
in front of the house?
and blocking every other car, so not to be used as driveway access for the other portions, the parking portions that are outside the 30-foot front setback. So you can't block that way in where it's a pretty well-defined way in. I know the snow plowing is one thing, but if we look over historical time, you see that there's one exit in and one way out. So I suppose if you arranged the cars to not block anyone else in, and there was a parking area within 30 feet that fit 5 cars, yes.
But I think we would still need to overcome what Misharkey found in the original adoption of the provisions that pointed to multifamily and commercial properties. Is where we have to get past that to even start the consideration of.
Why would we?
Because if we thought that the original change to the definition of creation of the definition of parking area only pertained to.
What's the bylaw say though?
Well, it's not in the bylaw, but I think you can point to other evidence from, contemporaneous evidence of what the intent was.
Why do you need to? Why can't you just rely on the words in the bylaw?
Because it's not clear.
Well, we're not seeing
ambiguous.
any of that.
What do you mean?
All the research she
So
did.
we haven't seen the evidence, and I'm assuming that it wouldn't be readily available to generate tonight.
I'm assuming that that's all true. I'm just saying, why do we need to go to that? Why?
You might explain what temporary means. The discussion around passing of the bylaw at town meeting, what people talked about. I mean, I just don't know. I don't know what any of it says, but
I guess I don't know that that's the first stop. It seems to me that if we can't even establish that it's a parking area.
Well, I think we wouldn't have to think about it if we said that parking areas could only be in commercial applications or multifamily residential. Then I don't think we have to consider anything else.
Okay.
But if we think that's ambiguous because it's not in the bylaw, and at most it was part of the discussion at the adoption, then yeah, I think you keep going down the tree.
Yeah, and I need to change what I said. I said I think it looks like a parking area. No, that's not really what I mean. I think it could be a parking area. That's what I think it could be a parking area. I don't necessarily think that it is because there's just not enough evidence in my mind to say that.
So what do you need pictures? Every day of the week picture of the 7 cars parked there out front? For evidence?
I would defer to what Ms. Sharkey needs. What does she need?
Because on some level, I think we're acknowledging there's heavy vehicle usage here, right?
Yeah.
So if we're not 100% of the way there, we're pretty close. But what gets us over that hump? I guess, to call it a parking area? Or what gets you over that hump to call it a parking area?
It's not temporary.
So you're saying it would never be a parking area?
I don't think so. We've looked at it at every angle.
I guess I'm surprised to hear that said, so I guess now I've got to ask, what is a temporary parking space versus a permanent parking space? Or, no, I guess I can't even say permanent, because that word's not there. So what is a temporary parking space versus a non-temporary parking space?
In the context of the zoning.
In the context of zoning?
It's not defined, but I would use the example of going to the supermarket, parking my car, going in, coming back out, temporary. On a parking, parking meter, parking sign, temporary parking, 15 minutes.
Whereas the house that I go into and come out of 10 hours later, that's temporary or not?
I don't believe so.
You think that's permanent?
Well, non-temporary.
Other than temporary.
I don't think.
What if I don't live there?
I don't think it's. I don't think it's. I think it's non-temporary. Because you're owning the property.
But what if I
We're
don't
going-
live there?
No, that's what he's saying. Visiting.
Oh.
There's a reason why it says temporary parking.
Oh, I wouldn't be so sure of that, but.
I would hope that there's a reason why it's a temporary parking. So, I mean, this could be flawed a bit, but I still.
Well, that would be a first in our bylaw.
that's
We'll work really hard to revise some things.
But that's why we're here. We're the cure-all for everything.
You're right. You're absolutely right. You're right. We're the cure-all, but I don't feel comfortable curing
No,
because it looks like.
Right. Well,
Right. And maybe I have a higher level of curing than others, and that's fine. But you're right. You're absolutely right. That's what we're here for.
I think part of that cure would be understanding what the intent of the bylaw was. So then it goes back to the
Little bit,
town
yeah.
meeting discussion. Because we're trying to interpret something that's not there.
So I said a little while ago that I think we should close in motion and vote. And then Peter said, or, and I don't know that I ever got, I think you were the one who said or. Like you had something else in mind. I don't know if we ever talked
just
about it.
if they wanted a continuance to get more
Oh.
evidence,
Okay.
pictures, whatever, dated pictures.
I feel like I'm with Peter on that as well.
What?
To get more
But
evidence.
that's their decision.
Yeah,
We
that's-
can't.
No, I know
do
we
it.
can't make it, but I agree with what Peter suggested.
I have a hunch there isn't more to get.
That there isn't.
If I may respectfully, I suspect two things. Number one, I suspect it's going to be a while before the O'Connors return back home, so that evidence isn't coming forward. And I suspect Mr. Talcott, who's listening to this meeting, is probably not going to be parking there for a while at least. That's just a guess. I could be wrong. So
I mean, I'll park within the boundaries. Do I need your permission to park on someone else's property? I guess that's my question too here for the ZBA. I do visit them, right? Is that like a zoning violation to park in their yard?
Well, you live across the street?
Yeah. We move stuff back and forth sometimes.
I don't think it's our. I don't think that's for us. I think
Maybe
that's
if, and I'm doing a maybe. Maybe if he's number 5 in the front yard,
what I was getting
but
at,
it would be temporary. So
I don't have any
Yeah.
hope that I would have 5 cars parked in there in the next, I don't know how long it would be. I also don't know if it'd be helpful if the members of the board just went and looked at it. I know, I've heard at least 4 of you at different times say, I think that looks like parking, but I'm not sure. Maybe it would be helpful to, and if that were the case, that the board wanted to just look at it, we would certainly not object to a continuance.
Well, you'd need to request a continuance.
We would request a continuance for that purpose as well.
Yeah, I mean, I've looked at it and I could go look at it again, but it's not gonna change, where I'm at.
I'd like to, I've looked at it, but I didn't do a deep dive.
I do have the notes from the bylaw amendment from May 13th, 1991 town meeting. I also forwarded it to you, remember, on the 23rd. I don't know if you want me to submit that to the board or just read it from the,
Actually, could you submit that to Katrina so we can make it part of the record?
yeah.
May we request a continuance then to allow us to also review that language?
Tracy, what date was that?
It was 1991.
No, when you forwarded it to me.
Oh, December 18th.
Before we do the continuance, you wanna just check and make sure there's nobody else.
Yeah, Katrina, anyone else?
And you're muted, Katrina.
Yes, there's another person. Hold on. Okay, Mr. Raymond, you can speak. I just need your name and address.
Mr. Raymond.
Hello, actually, this is Mrs. Whitehead. I live on the second floor at 60 Waterville Street. Are you able to hear me?
Yep.
Yeah, so what is your full name, ma'am?
Janine Whitehead.
Thank you.
I just wanted to kind of go on record here with the parking situation and to state that occasionally my children come to visit me, and I've had to deal with Mr. Bowman, who I have on ring cam video, threatening to tow my children's cars away because they're here visiting me. So I want to clear the air that I want my children to be able to come visit me from out of state without being harassed that they're going to be towed away. Also, the picture that was depicted earlier, where there were a lot of vehicles, I can say that the black vehicle in that picture has long since gone to storage many years ago. The Crown Victoria in that picture has long since been sold. The blue Chevy truck in that picture has long since gone to another area to be stored. And the red truck parked by the mailboxes has not parked there in over a year. That was kind of all I wanted to pipe in and say.
Okay, thank you.
So if we were to do a continuance, when would we be continuing it to? When's our next, Snow Road meeting?
Does it matter how long you continue it to?
If we go beyond whatever the statutory requirements are, they'd have to agree to it.
It's our request, respectfully.
Mhm.
The 100-day period wouldn't apply because it's our request to continue.
No, the only reason I'm asking that is because they did bring up the fact that the people that live there are in Florida and they come back whenever. So should we have the hearing the next, after beginning of May or end of April or something? Or is that too far off? I don't know. I mean, if I were them, I would wanna, that was stuck out in my mind that,
I think we could continue it to.
and this whole thing might go away between now and then. I don't know.
I guess, Mr. Chair, if the applicant's primary consideration would be looking at the language from the town meeting, council just pulled it up and it was fairly explicit. I don't know if you'd want to take a read through now and potentially change your mind about continuing. It's pretty explicit that the planning board brought the amendment.
I'd actually like time to look at that.
Sure.
What if we said, I don't know, March 12th?
The trouble with March is he said they won't be back.
If I may, I'm not that worried. I'm more concerned with the character of the actual area than I am about how many cars happen to be parked there when people walk or drive by. I understand some of the board members think
Okay.
that's positive, but I'm not gonna hold my breath for that photograph.
So March,
Well, maybe February 12th.
when is our next snow road meeting?
2 weeks, the 22nd.
Katrina, do we have any other 48 cases?
Not at the moment. A woman has been calling me that she will be submitting something, but I haven't seen it yet. I don't know when it's coming in.
I think February 12th probably works for me. When's President's Weekend? Is that the 16th?
It's the following week, yeah.
16th is
Yeah.
President's.
The 16th is President's Day.
Yeah, so the 12th would be better for me than the 19th.
The race is the 16th, so maybe the 20th.
Mr. Chairman, I'm sorry, if it's possible to schedule it a different week, later or earlier, my client will be out
I'm
of
gone
town.
for 2 weeks.
I'm gone that week too.
What week is that?
The 12th I'll be gone.
How about February 26th?
26th? Yeah.
That works for me.
February 26th?
Yep.
Yep.
Fine for me.
I'm out of town.
Well,
You wouldn't want to miss this either.
I mean, we can deal with that, right? Mr. Chairman, I move we continue case number 921 to February 26th at 7 PM.
Second.
Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams.
Yes.
Chairman votes yes. So, case 921 is continued to February 26th at 7 p.m.
Thank you.
Thank you.
Thank you, Mr. Chairman.
This is your big
Oh,
copy.
yes, thank you very much. Have a good night. Maybe I'll dream of something.
Thank you.
Thank you.
Good night.
You.
Wow. That's why I wouldn't want to be in a zoning enforcement officer. I gotta admit.
All right, so minutes.
Can I suggest we,
Push him again.
Brian's?
I thought you said push him again.
Well, I really wanted
He's
to do that too.
run in here and choke us.
Why can't we do what Brian did? Why don't we all just look at them at home and then send our notes? And do we have to do it together?
Yeah, because we have to vote on them.
Well, you can,
I mean,
you could send your corrections and then it would be
no, yeah, we have to vote. Yeah, that's right.
quicker
Okay.
when we do them.
I trust Brian found every correction needed, so let's just.
Well, some were questions, but
Yeah. I,
Is the red ones,
go through
your
maybe one
corrections,
of 'em.
Brian? Are these your corrections?
That Brian.
Oh, Brian's. Oh, that,
Smart Brian.
too many Brian's, yeah.
all right, sounds like we're going for it.
Yep, let's go.
Maybe Katrina could put up August 21s? I think that's the oldest one, right?
Mm-hmm.
But Brian has a question about the impervious area that Mr. Nguyen mentioned. I suggest we strike it, because I think the impervious discussion was more on our end. But I really don't recall, but I say we just strike that bullet.
I think it was. I'm good with that. I think it was consideration of whether or not the parking area
Right.
was pervious or not.
But we have it under discussion with the board, and I think that's probably sufficient.
And then I've got the same comment on here and.
So you're
one
saying
other-
that was a parking?
I believe Ms. Sharkey did. Just didn't know for the couple times that we had Snow Road without any testimony, just if we wanted to make that explicit.
I think we should. So I think what you called it out there, case 910, if there was no testimony heard, we should add a sentence. Katrina, are you getting this?
Yeah, I am.
I think there should be a sentence added there.
Yep, that was my error. Sorry about that, guys.
And I didn't have any other changes on that.
Yep, same here.
Mr. Chairman, I move that we accept the meeting minutes of August 21st, 2025 as amended.
Second.
Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams.
Yes.
Chairman votes yes.
All right.
Did I get us out of hot water, Katrina? Can we go home now?
If we get them all done, yeah, the clerk will stop yelling at me.
All right,
Let's
September
do,
11th.
let's do another one. Do the next one.
September 11th.
Yeah.
I'd rather see basement than ground floor, because basement, that question was asked, and I have to admit, I didn't look at the plans good enough that I just assumed there were basements, so that was pretty important to me.
But I don't think they're subsurface. I think they're the same level as the garage.
There is no basements
Right.
in them.
Right.
I don't even know about the new ones now, but
I don't think so.
those back then, I think Bill asked a question, I was surprised when I found out there was no basements.
If there was 4 of the buildings in the quadrant, but if there's only 3, they're gonna do you mean the underground part?
The townhouses.
Oh, the townhouses.
It was the townhouses.
Yep. So what are you saying? You're saying that you don't want to call them basements, or you do want to call them basements?
No, the question was asked about basements.
But what Brian is saying here
Should
is
be,
the architecture drawing, it says basement plans for townhouses, and he's saying, no, it should be ground floor. And I think he's right,
agreed, yep.
because they're not basements, they're ground floors. And then what is the ground floor will it?
Correct, and maybe we need a sentence that there was a question asked if there were basements. Cause you asked about storage in the basements. And
Okay, I'm fine with that, if we add a
we
bullet.
could add that.
Question
Okay.
asked,
Okay.
if there was basements, answer no.
Right, there's no basement. The ground floor is going to be, pretty much all garage.
Correct.
I'm also good with Brian's comment about trash recycling pickup frequency.
Yep.
Okay.
I do like, this is, September 11th, and, we have, get a new flyover video without leaves on the trees. We still haven't got anything.
And you probably should change Brian's comment, so you know, he's the one who said it.
I just don't want the implication that anybody's comments are invalid.
Yeah, good point.
Geez, you catch everything.
I wouldn't say that.
Yeah, and then a couple other ones I think are good to go. Anyone else have anything? Otherwise, I'll do a motion.
Good to bind me.
Mr. Chairman, I move we accept the meeting minutes of September 11th, 2025 as amended.
Second.
Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams.
Yes.
Chairman votes yes. October 1st.
Should it be stated that there was, I mean, it says applicant request, oh, okay, Brian, all right, Brian already fixed that, should we? I agree, it should state no testimony was, given.
Which one are you on?
September, November 12th? Are we on November?
October
October
1st.
Come on, October.
Oh, jeez. Helps to be on the right one, huh?
Was I really remote on October 1st?
Yes. Was that when you were in Australia?
I don't think you did one when you were in Australia, did you?
I would have been, I don't think so.
I don't know, but I know you've been remote a couple of times, Bill.
Maybe you weren't, yeah.
I think it was when you got back from Australia or somewhere else.
Yeah, you weren't feeling well or something, maybe.
That was the most recent one.
Oh,
Cause this is when we went through.
Oh, you know what? You might know. You were here. I just duplicated it from the previous one. Nope, you were here.
Yeah.
That's me just cutting and pasting. Sorry.
Yeah, cause then we get a Dan's memo and I know I was here for that.
Yep. And I can go back and double check the video, but that's my cutting and pasting. I'm sorry.
I'm good otherwise.
Anonymous attendee question online.
Was that a red comment? Like a typed comment?
Must have been.
And then, on the first page, did we want to say anything more than just kind of the general reference to workshops? Discuss the potential for workshops or?
Where's this?
First page.
Well, certainly the typo for applicants. Yeah, I see your point.
We could remove it entirely under
I think remove it
attorney.
entirely.
Yeah, under Attorney Hill, there's a bullet for take request from applicant for workshop.
Yep. Yep.
Okay.
So you're removing the word workshops and a hyphen, right?
Yep.
Mr. Chairman, I move we accept the meeting minutes of October 1st, 2025 as amended.
Someone want to second that?
Second.
Ms. Reed,
yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams.
Yes.
Chairman votes yes. November 12th.
Wait a minute, November 12th, there was no testimony heard?
No, they had asked for continuance, so basically I think it was me and Alex and someone else just showed up and we opened it and continued it. Cause that was when they were trying to redesign everything and we were scheduling the workshop for November 19th.
I mean, it says members
Present,
present.
all of us present, except
Well,
for,
yeah, because you were either online or remote. Everybody appeared, but we literally opened it, we continued it.
Then
I don't remember being there for that.
You were. I'll double check the video, but yeah.
Okay.
I'll double check the attendance on the video, but I think almost everybody was there that night.
And just to
And we
add,
opened it and continued it. Then no testimony was heard. Yep. I'll add that in.
And do you need an and right after Brian Langevin or and absent? Do you need that and there?
No, I'll fix it.
and then you'll update it to say remote for anybody that was.
Yep. I will get online and look at the video. Sorry about that, guys.
And, I move we accept the meeting minutes of November 12th, 2025 as amended.
Well, actually, 1 second. What gets read at the beginning of the meeting, is that the rules of order or is that like the open meeting?
So usually it's you read the remote rules and the rules of order. You usually do them both combined.
That's the rules of order?
Well, you do the remote, you do
I
the
know there's,
remote
like, I didn't know
rules
that's what
of
it's called,
order.
but- Sorry, I'm splitting hairs. So yeah, sorry.
Second.
Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams.
Yes.
Chairman votes yes.
I move we adjourn.
Second.
Ms. Reed,
Yes.
Mr. Mejia,
Yes.
Mr. McCusker,
Yes.
Mr. Adams,
Yes.
Mr. Langevin.
Yes.
Chairman votes yes. We're adjourned.
Good night, everyone.
Good night, everyone. Thank you.